Good afternoon, and welcome to the Appellate Division First Department. Today we have over 7 hours of oral argument time requested. So as I call the calendar, please only request the time that you need to make your most salient arguments. I assure you that we have read your briefs and we are familiar with the underlying issues of your appeals. For those who are with us for the first time, the white light on the lectern will go off when you have 2 minutes left, or if you've requested less than 2 minutes, it will go on immediately. When the light turns red, that means your time is up. If the panel has further questions past your allotted time, we will keep asking them, and you will have an opportunity to respond. When I call your case, please rise and tell us who you represent and how much time that you are requesting. Remember, it's the time that you need and not the time that you want. And as you can see, Justice Chan is with us and will be participating virtually. With that said, the first case, People v. Dashim Green. All right. 525. Ambrose v. City University Construction. All right. 42424. A. Ola is submitted. Scaglia v. Hart. If I'm mispronouncing anything, I'm apologizing in advance, and you will correct me so I can pronounce it the correct way. Please. Mm-hmm. All right. 414. Thank you. Casserier v. Gottlieb. Mm-hmm. All right. 525. People v. Rashid Davis. 525. Moreno Santos v. Real Builders. All right. 52525. Thank you. McIntyre v. FNYGP LLC. Can you repeat that again? I'm sorry. Mm-hmm. All right. 525. Kramer v. Edelstein. All right. I'm going to give each one of you 2 minutes because the appellant is not here, or you can submit. What would you like to do? Okay. All right. Lifshitz v. Brody. No. So would you like to submit? Okay, submitted. Thank you so much. Tecton Builders v. 1232 Southern Boulevard. Good afternoon. Tecton. And that's what you shall have, 5252. D. Emily v. Meshach M. right. You want to submit? All right. We'll give you 2 minutes. People v. Michelle Merritt. Submitted. Air Products and Chemicals v. World Energy. Yes, that permission is granted. All right. 6-2-6. I think there's better weather in California. Am I right about that? Oh, this is better here. Okay. Veloso v. City of New York. 525. Phone Administration Services v. Verizon, New York. All right. It's granted.
Your Honor, if plaintiff appellant is requesting 6 + 2, 8, we would request 8 as well.
So 6-2-6-2. I thought there's also a cross appeal, no?
No.
Maybe, all right. That's what I'll do, 8, okay? People v. Charles Washington. Submitted. And last case, Tenio v. Bogart is submitted. First case up, People v. Green.
Good afternoon.
Good afternoon.
William Carney for Appellant Dashim Green. The Sora Court below erred in its assessment of 30 points under Factor 3, the number of victims, and 20 points under Factor 7, the relationship with the victim.
Let's start with Factor 3, the 3 victims, right?
Yes.
Because you have the 15-year-old, there was the birth certificate that was produced. You had the 14-year-old, and that came from the defendant, and then a third person, and that was the friend of the 14-year-old. And more likely than not, I don't think we have like 21-year-olds hanging out with 14-year-olds. They're pretty much in the same age group. And then, we have the photos, the messages, the ads. I know this all came in the grand jury. So what's the error?
The error is that the people have to present clear and convincing evidence under all of these standards. They presented clear and convincing evidence of exactly one of the individuals, the 15-year-old that appellant pled guilty to, and also they presented a birth certificate regarding the one you said was 14. In fact,
15 for the birth certificate.
14. The first is 15. The second, 14. But appellant said when he pled guilty that she believed or he thought she was 14. He didn't know for sure, and the people never presented any evidence of her actual age. And then they tried to use that to then say, oh, well, the third one must be around her age. That one wasn't the product of any indictment and not really anything that he pled guilty to. The second one, by the way, I think not significantly, was an attempt count. So even then, I think because it wasn't really clear this person's age, that was prosecuted as an attempt. Now, the court here, the people are relying on speculation for this. They're reasoning back. Sorry, I'm talking about the other points. Sorry. They're relying on the photos. But if you look at the photos, there are 13 separate photos, many of them of the same person. But most of those photos don't even show the person's face. They show them from behind, and they're focusing on the person's behind. So it's hard to tell someone's age when you're looking at their back. And then even the ones where you see their face, well, all they're saying is, well, it looks that way to me, but not everybody, just the fact that that is someone's opinion. I mean, if a defendant was brought up on a statutory rape charge, decided to say, oh, well, the person looked like they were 18, obviously that wouldn't be any kind of defense. And the people who are obligated to present clear and convincing evidence can't give their own personal opinion of what that person
So the people
looks like.
can rely on circumstantial evidence, though, right?
They can, rely on what?
Circumstantial evidence.
Sure, if it amounts to clear and convincing evidence, it can't be.
Why is
can't
what
be
we have here? Why is what we have here not circumstantial evidence that rises to the level of clear and convincing evidence?
Because the 15-year-old was clear and convincing. The second one, where the defendant said he was 14, it's not clear where that even came from. In the record, it says that a police officer.
It came from the other circumstantial evidence in the record, wherein there was information about a friend to the 15-year-old, a friend to the 14-year-old.
Well,
That wasn't in the record?
no, that is in the record. But see, you're saying a friend to the 14-year-old. That's not actually in the record, that her age is really 14. So that's a problem to this is circumstantial evidence argument. It's not clear and convincing unless you have proof of at least the second person's age, and certainly not the third person's age, just saying this person is a friend of somebody else. Because, okay, maybe you're a teenager, but you could certainly have friends that are 18 years old. That's also...
Counsel, in terms of the age, is that not what the defendant pled to? He didn't take a plea with regard to the ages of the victims?
No, well, the first one, certainly. The second one is, I think, which is not pleading to
Well, the
that
I
age.
think was where? In the pre-sentence report? Or was that
That's
at the
where
plea?
he said he was told by somebody, we have evidence that you were pimping a 14. Now,
What did he
somebody
plead
told him
to
that.
when he took the plea?
Attempted promoting prostitution under CPL 23022.
Do you want to address
And that requires...
Factor 7?
I would like to. Actually, I was planning on opening on that, even though I know it's out of order. But that one, the evidence seems to me very clear-cut that there's a vast hole in their case where they're trying to reason backwards from the idea that after this 15-year-old ran away, and then 1 month later, she appears in an ad for in backpages.com. They never presented any evidence as to how they met, that they were complete strangers. Instead, I mean, even the court was
Is the issue
compelled.
that they were strangers or that the defendant engaged with the minors for purposes of victimization?
Well, there's two factors, right? It's either a stranger or for purposes of victimization, and they didn't present evidence of either. They're just trying to reason backwards to say, oh, well, this must have happened because this thing happened later on. But that is not clear and convincing
What
evidence.
about the posting of the online advertisements and the threat of violence against one of the victims?
Well, there's no, I mean, the fact that somebody later threatened violence actually doesn't say anything about how that they met for the purpose of victimization, something that occurred subsequently. That's the as we said, that's the logical fallacy, post hoc propter hoc, which means that it's something that doesn't make sense. You're not allowed to do logically. The court in this case, remember, the court asked the prosecutor is there any evidence of how they met? And the prosecutor had to candidly admit, no, there is none whatsoever. And then the court asked defense counsel, well, can I draw the inference? The defense counsel said, no, you can't speculate on this. There has to be information about how they met in the record, and that's their burden to provide clear and convincing evidence. And
All
they
right, well,
didn't
you'll
do that.
have time on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court. Andrew Kim for the people. The SOAR court properly adjudicated defendant a risk level 2 sex offender in this case. Contrary,
It seems that the circumstantial evidence here, how do we get it really to be stronger evidence to support the 30 points under factor number 3? It seems very circumstantial to me, and I don't see where it rises to the level it needs to be.
Sure, Your Honor. And I can certainly address how, kind of going along with my colleagues' points, that there wasn't a sufficient showing of age. But I'd like to also just take a step back, Your Honor, because the precedent set by the Court of Appeals makes clear that under an assessment under risk factor 3, there does not need to be a showing of age in terms of number of victims. The Court of Appeals made clear, citing the guidelines at page 10, that when it comes to the number of victims, the court may consider the number of victims that stem from the defendant's general misconduct. The victims do not specifically have to be victims of a SOAR level sex offense. So, guided by that precedent, Your Honor, there was clearly 3 different victims in this case, particularly 3 young girls. Would Your Honor like me to go into the evidence of the age given?
Well, I think one of them we had a birth certificate for. That was the 15-year-old. So the 14-year-old, where did that come from?
14-year-old, Your Honor, comes from the defendant's own statements. He admits to the court that he believed that the second victim was 14 years old. He admits to the Department of Probation that that information came from the victim herself, that she reported to him that she was indeed 14 years old. And he also volunteers this information to his associate in the private Facebook messages, saying that he just ran into a 14-year-old girl that he would like to get involved, as well as her friend.
And then the friend is even more circumstantial. I mean, there's nothing, I may have missed it, but I didn't see anything in the record that ever really figured out a number for her or an age for her.
Sure, Your Honor. In a sense that the evidence with regards to the third victim's age is a little bit more circumstantial, but given the totality of the circumstances and all of the submissions before the court could look at all of the photos showing clearly 3 different girls and make its own determination as to the relative age of all 3 of them and the approximate age for that third victim. I'd also like to just highlight, moving on to risk factor 7, that the defendant in this case, particularly with regards to the 15-year-old, exploited a very vulnerable child. She was in need of help. The evidence shows that she needed to be hospitalized. She was without her medication, and the defendant kept her away from her home. He didn't report this to the authorities, and instead repeatedly subjected her to sexual contact with multiple people, sometimes against her own will, or because there are times where he had to threaten her. That's what the evidence shows. Because of her attitude, or because to the defendant, he felt that she was being lazy.
Is there a problem because there seems to be no evidence as to how he met and how the relationship developed? Do we need to be concerned about that and finding, in assessing points under that factor?
Absolutely not, Your Honor. Like in many trials, intent can be inferred from the defendant's conduct alone. And in this case, the evidence clearly showed what he did to each of these 3 girls, and it even showed how he referred to them, the derogatory terms he used when referring to them to his associate.
So I wonder if you want to take a moment, although the appellant hasn't had a chance to reach this yet about the departure, and was the court correct in denying the departure notwithstanding these other issues?
Sure, Your Honor. Downward departure was certainly not appropriate here, given the defendant's proclivity of victimizing multiple young girls. That's a significant factor in terms of assessing his risk of reoffense. And certainly, perhaps more importantly, that goes to show the great magnitude of harm that would be caused if he were to reoffend, given that all of the victims here were children. And so for these reasons, a downward departure is not warranted. Absolutely not. And if there are no further questions, we ask that you affirm.
Thank you.
Yes, with regard to the argument that respondent just brought up regarding the Court of Appeals case in People v. Izzo, that wasn't brought up before the hearing court, nor did the judge rule on that issue on that basis, and therefore it suffers under people's preservation because the law is clear, as this court just decided on March 10th in People v. Lazara, that people's preservation applies, and that was a SORA case as well. So if they didn't raise it before the court, that is waived and not something this court should consider. But going to the merits, as they did regarding the age, it's clear that even within Izzo, it's distinguishable on its facts, because in that case, there were 3 decidedly underage victims. And then when he violated his probation regarding those 3 underage people, he again interacted with an underage person, and that was for something that didn't qualify as a SORA offense. But
Counsel, could you, before your time is up, could you also address your request for a downward departure, even if we were to?
Certainly. Yeah, we're just, he was assessed 85 points.
Right. At
70, he'd be a level 1. He had this is a very, he didn't have a prior offense under the youthful offender. This was something that happened. The court itself said he was a minor player in this entire scheme. The other people were the major players. He had a close relationship with his family. He was interviewed by a psychiatrist who spoke with him and said he had little chance, almost no chance to recidivate. The conduct in this case was just over a 30-day period and these 13 photos. And the defendant admitted his guilt, deeply regretted it, he said. And I think all of those are mitigating factors that should warrant a downward departure in this case.
Thank you very much. Ambrose v. City University Construction Fund.
May it please the court, I am Martin Adams, counsel for defendants appellants. I respectfully request that the order of the trial court be reversed and defendants appellants' motion for summary judgment be granted, both dismissing the complaint and granting contractual indemnity. If this court is not inclined to grant unconditional contractual indemnity, at least partial contractual indemnity should be granted, since this case clearly arose out of the work of the third-party defendant indemnitor. In fact, the indemnitor was the employer. With respect to plaintiff's 240 claim, this is not a claim involving a physically significant elevation differential. Therefore, Section 240 of the labor law does not apply.
Well, I thought that we've had some cases which have said that even if the height differential is not that significant, if under certain circumstances, that would not preclude outright a 240 case.
Correct. I'm not saying that there's a minimum. I'm not saying that. But in this particular case, where the defendants argue it's only 1.5 inches, even the plaintiff said it was 6 to 12 inches, but the plaintiff himself was unable to specify. He said it was somewhere around there. He was unclear about that. And in the cases which are cited, in all of them, I believe it's more than 12 inches. This is not a case where plaintiff fell off of, even if it's a few inches, where plaintiff fell off of a workstation, a platform, or an equivalent of a scaffold.
This is the case where he stepped, I'm sorry, we have 3 240 cases.
Okay.
So this is the case where he stepped out of the elevator, anticipating that there was going to be a ramp, which wasn't there, and there was a misleveling between the elevator and the floor.
That's right, although I'm not sure he anticipated a ramp because he had not been on that floor. He simply stepped back to let other people off the elevator, and so he can then go to his workstation on another floor, and that's in fact what he did. He stumbled and then went to his workstation on another floor. This is more of a horizontal type of accident as opposed to a fall, which would be covered by 240. Horizontal accidents are not covered by Labor Law 240. Accordingly, the trial court erred in not dismissing the 240 claim, and in addition, as I point out in my brief, the 200 and common law negligence claims also should have been dismissed.
So why you mentioned about at least you should get conditional indemnification at this point. Why would you be entitled to that? Because you're claiming that there's no negligence that could be found against your client?
That's right. In fact, I'm saying, and in my brief I say there's no negligence at all on behalf of the appellants, and therefore the contractual indemnity should be unconditional. But my learned opponent, third-party defendant, argues that there's an issue of fact, and therefore I am not entitled to, my client's not entitled to indemnification. I argue that even if this court were to accept my learned opponent's argument, we should still get conditional indemnity, because it's clear that this accident arose out of the work of the third-party defendant. I'd be happy to answer any further questions.
I do have a question, because I think there are some issues of fact as to whether or not your client was negligent. And the reason why I'm saying this is because there's some testimony about possibly it was your client who removed the ramp. I mean, it's really not clear.
Well, respectfully, there's actually no testimony at all that my clients removed the ramp. Instead, there was one excerpt from my client who testified that jurisdictionally, my client does have laborers on site, and a laborer may have, a laborer, not my client's laborer, but a laborer may have removed the ramp. But there's no proof the laborer was employed by the appellants.
All right.
Thank you.
Thank you.
Good afternoon, Your Honors.
Good afternoon.
I represent the third-party defendant, respondent, cross-appellant B&G. One issue that I would like to raise is, and clarify, is the court below at some point during the, in their decision seems to have granted summary judgment to plaintiff.
And plaintiff didn't move for summary judgment.
Correct. So I did want to just raise that because there is evidence in the record indicating that, you know, plaintiff essentially stepped backwards off an misleveled elevator. And it's conceded that plaintiff didn't move for such relief down below. And this doesn't really appear to be the type of case where the court should search the record and grant such extraordinary relief based on the facts.
So what about the contractual indemnification? I think you moved to dismiss certain claims that might not have been opposed. Could you get into what you think is the right thing here? Since your friend over here called you his learned adversary, so.
Well, my learned friend and adversary was, I won't vouch for whether he's correct on that or not. But the court should have dismissed the common law indemnification and contribution claims that are asserted against my client. We are indisputably the employer here, and any
No
common
grave
law.
injury.
There is no grave injury here.
It was a knee injury, unfortunately, a knee replacement.
Potentially a knee replacement at some point down the road, maybe, which I've also had. But yeah, there's no grave injury here, and those claims should have been dismissed, and there's no opposition to those to that motion, either below or here.
Right.
With respect to the contractual, the third-party plaintiffs, the defendant's third-party plaintiffs here, they did not and they cannot establish their freedom from negligence here. There was testimony by Turner's own witness that a laborer would have removed the ramp.
Aren't they, in their role in this construction project, responsible, amongst other things, for coordinating the trades and
Correct.
sort of making sure that everything is safe, even if you have a separate site safety expert?
Well, they had a site safety manager that they
Right.
hired. In
Well,
order
that's
to-
common.
Yeah, of course, but their responsibility was obviously to provide for the site safety, so that's why they hired somebody to do it. But the removal of the ramp by a laborer, which is conceded by Turner's witness, the site safety logs and the daily reports indicate that in the 2 days before the plaintiff's accident, which occurred before work actually started on that Monday, the only laborers that were on site were Turner laborers. So if it was removed in the 2 days before, it was then done by Turner's own admission by their laborers. If it was done more than that before, clearly there's long enough for there to be constructive notice of its removal, if not actual notice, because it's at least 3 days before the thing, before.
Sir, what's the relationship, though, between their alleged negligence and the contractual indemnification clause, which, as I read it, is an arising out of form of indemnification?
It is an arising out of clause, and I'm going to be a little perhaps overconfident here when I say when the 240 claim is dismissed, there is going to be no way for anyone, any of the defendants' third-party plaintiffs, to not be found negligent here. The only negligence that's really attributable to B&G is potentially that of the plaintiff himself in stepping backwards and perhaps not looking to see what there is to be seen. That's going to be taken off the top if this is not a 240 case. So the only other negligence there is going to be on the verdict sheet is going to be that attributable to the defendant's third-party plaintiffs. And therefore, there would be nothing for us to indemnify them for. So if the only negligence is theirs, they can't be indemnified for anything.
And before you sit, just so that we're clear, you are also not opposing the dismissal of your counterclaims, correct?
That's correct. Yes.
Okay, thank you so much.
Thank you.
Good afternoon, Your Honors. Erica Colon with the Parisman Firm for the plaintiff respondent. It's my position that the trial court properly denied the defendant's motions as to 240 subsection 1 and Labor Law 200. First, pointing to the 240 subsection 1 claims, the removal of the temporary construction ramp created an elevation differential. Despite it being arguably a minimal elevation differential, it brings this case within the scope of the protections of Labor Law 240 subsection 1.
But was the risk of misstep off the elevator the type of risk that 240 sub 1 was designed to protect against?
I think that it is, Your Honor. We have an admission in this case by the defense witnesses that the ramp was placed to serve a safety purpose for the workers. It may not have been the primary purpose, but there is testimony.
It was so people could transport material around, but it did, somebody also testified that it also was for personnel to get around.
Correct, yes. The primary purpose was to transport material on and off the elevator, but it also served a purpose, a safety function for workers as they were entering and exiting the elevator. Now, my client may not have anticipated that a ramp was going to be at the opening of the elevator, as counsel pointed out, but he certainly anticipated that there wasn't going to be an elevation differential. He anticipated that he was going to be stepping out of the elevator onto even ground, which wasn't the case, because not only was the ramp placed as a safety protection, we have testimony that the ramp, there's evidence in the incident report that the ramp was removed, And there's testimony that if the ramp was removed, it constitutes a dangerous condition. With all of those factors in mind, plaintiff's testimony that the elevation differential was between 6 and 12 inches, we know that there is no bright line minimum here. And as recently as last year in Palumbo, this court ruled that the low end height
Counsel,
differential.
wasn't Palumbo the facts very different, where there were two pallets put together that the plaintiff there was required to work on as part of their work safety device?
Sure, the facts are
And we don't
different there.
have that here. We have a construction site where there's potentially an issue with someone walking to get to their section of their work.
Sure, but respectfully, it's conflating two issues here, because it's not of any object whether he was working in the midst of the step off and height differential. What matters here is that there was a safety device that was removed, and even though
Well,
in
it can't be
Palumbo,
any safety device. It has to be a safety device enumerated in 240 sub 1 or of the type specifically enumerated.
correct, and we have an admission that in fact it was, because the purpose of the ramp itself was to prevent workers from being subjected to gravity-related height
I
differential
just
here.
want to go back to Palumbo because, you know, in that case, I mean, it was a fall from an elevated work surface. And here, you know, it's the ramp, and from my reading, the ramp was really to transport materials to and from, and you don't have a fall from an elevated work surface as you did in Palumbo or as you did in Marte, which is one of the cases that the motion court relied on.
Sure, well, we don't have a fall from a place where he was working, but we certainly have a fall from a height. And in the low estimated height in Palumbo was 10.5 inches, and the plaintiff in Palumbo was granted summary judgment. Here, the high estimation is 12 inches, and we have testimony that the safety device, the ramp itself, was removed, which raises a question of fact here. I understand this is a close call. We did not move on summary judgment for
Even though
240.
even though it appears the court may have granted that to you, you never moved.
We did not move on it because we appreciate that there's a question of fact, and I appreciate that there's a close call, and I recognize the court's concerns, but taking all of the factors into account, I do feel that we have created, there is an issue of fact that exists, and the height differential here, given the safety concerns and the safety device that was removed, the ramp, the trial court's ruling should be affirmed.
Thank you.
Thank you.
The contractual indemnity provision does not require that the indemnitor, third-party defendant, be negligent. Accordingly, even if at trial the third-party defendant is not found negligent, contractual indemnity still applies. With respect to Palumbo, that case involved a stack of pallets that was used to gain access to a wet saw, which itself was elevated. The pallet structure was, according to defendant's own admission, was improper work platform and against safety rules, and plaintiff fell from a height of 10.5 inches to 20 inches. So Palumbo has no application to the case at bar. Plaintiff was not actually working at the time of the accident. He was not working, and in addition, there's
Well,
no...
wasn't he just in an elevator going to where had to get to where he started to work?
That's right, that's right. It was used simply to transport him. There's no claim that the elevator itself was defective or contributed to
Oh,
the
I
accident.
understand.
Accordingly, I
Wait,
respect...
wait a minute, I just want to go back. So you're saying that he wasn't working at the time? Did I hear you right?
I'm not saying that, no.
Okay.
I'm saying that he wasn't actually performing his telecom activities. He was on site and he was being paid as an employee as was proper. No, but I'm not saying he wasn't working at all.
Right, because I mean, you know, he was on the work site, he changed into his gear, right? And he entered into the elevator to report to work, right?
He was reporting to his workstation on another floor by using the elevator. That's correct.
Okay.
I asked that the order be reversed and...
Sir, do you have a GOL 5-322.1 problem?
No, because there is a savings clause in which I quote in my brief, which overcomes any 5.322.1 problem. There is no such problem because of the savings clause in the contract itself. Thank you.
All right.
Two quick issues. With respect to the 240 claim, the Court of Appeals has made it very clear that the elevation differential must be physically significant. Just by using those words, it invites the conclusion that at some point it becomes physically insignificant. I submit that here we have that. This is not the type of elevation differential to which the types of safety devices enumerated in the statute really apply. Sure, there may be a ramp there, but that ramp really was not there in order to assist somebody in stepping down what may be as little as 1.5 inches. So again, I press the argument that this is not a physically significant elevation differential to which 240 applies. With respect to the, my adversary just used the words that the contractual indemnity applies. The question, which I tried to highlight before during my earlier argument, is applies to what? If this is not a 240 case, there will be no circumstance under which any of the damages that any of the defendant's third-party plaintiffs will have to pay is attributable to any negligence other than their own. So
once those statutory claims are out of the case, then the contractual.
correct. If 240 is out of the case, and even if 241.6 is in the case, it's somebody's negligence attributable to the defendant's third-party plaintiffs. This is a wrap-up case. So whoever took out the ramp they're all insured. They're all under the same insurance anyway as the rest of the defendants. And the only reason we're standing alone as the employer is because we're the electrician and not under the wrap-up.
Thank you very much.
Thank you.
Scaglia v. Hart. Before you start, I said 1 minute for rebuttal. I'm going to make it 2, okay? So 4-2.
Thank you, Your Honor.
You can begin. Thank you.
Good afternoon. Alexander Staken for plaintiff appellant Silvio Scaglia. In granting a default judgment of divorce in favor of the defendant respondent Julia Hart, the trial court erred because in doing so, it also determined the respective rights of the parties in their separate or marital property without issuing reasoned findings of fact and conclusions of law as required by CPLR 3215 and DRL 236B5. In fact, instead of doing that, what the court did is it adopted what in effect was a wish list submitted by Ms. Hart containing all the relief that she wanted, an order to show cause drafted by her attorney that the court signed off on without issuing any reasoned findings of fact.
Your client, I thought, did not oppose the order as to the divorce. The divorce was okay. It was everything else that you wanted to send back for some type, the DRL analysis, which seems to have been missing from this case. Am I correct?
Yes, Your Honor. We are appealing those findings of fact, or the lack of those
The
findings
lack
of
of
fact.
the findings
Yes,
of
we're not
fact.
appealing the default, the divorce judgment. Yes.
Right, because, for example, the $7.4 million in management fees, do we know how the court reached that determination? I mean, is there anything that the wife presented, to have the court make that determination?
Your Honor, I think your question sort of gets at the problem here with this order, which is that this court, the appellate court, should not have to guess as to the basis of the court's opinion. And in fact,
It may happen other times, but with the DRL, I think it's a little more restricting as to what the Supreme Court has to send up to us, correct?
that's true. That's true, Your Honor. In fact, the DRL specifically says that this requirement is not waivable. And the appellate courts are unanimous in holding that this type of determination has to be made by the trial court. In fact, even a conclusory statement. That's in the case of Fregella v. Fregella, where the court quoted the needs, finances, and circumstances and standard of living of the respective parties. Even such a conclusory statement was not deemed sufficient. Here, there's not even that.
Could I ask you, the one thing that was a little confusing to at least me was the power of attorney. So the court granted your adversary, the wife, a power of attorney for what purpose? I thought there were two powers of attorney. Am I wrong?
Yes, Your Honor. The power of attorney was, it's not entirely clear because on the application for the power of attorney was really for the purpose of overseeing, there was some sort of a foreclosure proceeding over the marital property.
Well, counsel, when you say it's not exactly clear, wasn't it geared to preventing dissipation of assets?
Well, that is separate from the main award here, which was really for 50% of the company.
Well, I was discussing the power of attorney.
The power of attorney, yeah. I mean, that, it may have been. Again, we don't know because all we have is a wish list from Ms. Hart that was signed off. We don't have those kinds of reasonings of conclusions of law and findings of fact that the court needed to put forth.
I think the same thing can be said about the painting and FHI, correct?
FHI, that's right, Your Honor. Yes, FHI is a multi-million-dollar company where the court, again, without any kind of reasoned findings of fact, awarded her half the company, even though there was substantial evidence in the record, including a finding of a Delaware Chancery Court that she's not entitled to that relief.
All right,
Thank you.
Thank you.
Good afternoon, Your Honors. For the respondent, Julia Hart. Context matters, and this is a divorce case that began in or about 2022. It's been pending in Supreme Court in New York County since that time. The motion...
No, but why wouldn't we need to send this back? I mean, there are no findings of fact. Certainly, you know, how did the court reach its determination with respect to the 7.4 and the management fees, you know, the distribution of the FHI, and then, you know, the painting. You know, we have the Delaware court that said, you know, 49.99 interest. Your client said 50, but where, you know, what is the award based on? You know, we don't have any findings, and it is required.
So the order that we're discussing is an interim order that ultimately resulted in an inquest taking place before Judge Perlman, which has been concluded at the present time, and we are awaiting the final judgment of divorce together with the court's findings of fact.
Did it say interim? Did it say interim?
It does not say interim. However, I refer you to page 3 of 5 of the actual order, which actually sub-items D and E refer to the very inquest that I'm referring to over here.
But counsel, this particular order, is it not correct that under the DRL, it requires that there be findings of fact?
No, it does not.
And why is that? What provision of the DRL precludes there being findings of fact?
Because this is an interim order, it's not a final judgment.
Right, but did it say that it was an interim order? Is there anything within that paperwork that makes it such that it is in fact an interim order?
Yes, and the fact that it's specifically referring to an inquest that will be conducted in the future leads us to only one conclusion, namely that it's interim pending the final judgment.
But there was all of all of this resolution of assets. How is that interim?
So the actual motion sequence included approximately 100 exhibits that were submitted together with the papers. The underlying application stems from Mr. Scaglia's failure to appear in the case, failure to comply with discovery, failure to comply with court orders directing him to pay fees to court-appointed the Honorable Stephen Crane.
It's clear that there were a lot of failures here, which is why this was entered on default. But I'm still struggling to figure out how, when there is an award of 50% of interest in a company, that is an interim award.
So what the court did was it basically gave Ms. Hart what the record demonstrated she has been promised and was entitled to, Namely, the record contains,
But then that's not interim, right?
well, it's interim, well, that's why I started respectfully with the word context matters.
But the context would have been in the findings of fact. That's where we would find all of this context that you're referring to, if we had it.
Well, not necessarily for the following reason. The context also goes down to the lower court who has discretion. So Judge Perlman, who's been presiding over this case and is intricately familiar with the underlying record and the appellant's failure to prosecute the case, failure to appear in court as ordered, failure to comply.
Discretion is cabined by the law. And so if an interim order to me sounds in protective measures. So one spouse is dissipating assets or engaging in waste or fraud. There's a company and someone needs to be supervising the company. Wouldn't that be taken care of by the power of attorney? And then within, if there are going to be final, as Justice Michaels was touching on, if there's going to be some sort of final distribution or final determination, shouldn't that await the final, the inquest/final judgment?
Your Honor, in the context of the way you just phrased it is correct. This order was designed to protect Ms. Hart and the assets themselves. Firstly, the power of attorney was awarded to her so that she can appear and defend against the foreclosure of the apartment that Mr. Scaglia failed to
But that's
defend
been
against.
resolved, hasn't it?
Well, it's only been resolved recently because the apartment has been sold. Now, in terms of the apartment, the FHI, the business.
Right.
The business was transferred by Mr. Scaglia in violation of court orders to Europe. The purpose of this order, the interim order, was so that Ms. Hart would have a piece of paper to show anyone who was contemplating purchasing, acquiring in any manner this asset, this marital asset that Ms. Hart owned, at least pursuant to the Delaware court 49.99% of. Now, how we get to the 50%? We get to the 50% because under the domestic relations law, the Supreme Court is a court of equity. Court of equity has the discretion to award a spouse anywhere between 0 and 100% of an asset.
At the equitable distribution stage.
Well, that's why over here, Ms. Hart is getting simply the 50% that she was promised and that the documentary evidence that was provided to the court in the underlying motion sequence number 19 was provided with. The judge had the documents showing the 50% that was given to Ms. Hart by Mr. Scaglia.
But we don't know that because we don't have any findings of facts before us to rely upon.
The court, however, does have the documents.
We don't know that that's what the court below relied upon in making its determination because there's nothing before us regarding the court's findings of fact.
Well, those very findings of fact, that's what we are now awaiting from the lower court. Because we have now concluded and had the inquest, that's when those findings of fact are issued. The move-in references CPL Law 3215 inaccurately. 3215, Your Honor, refers to final judgments. We do not have a final judgment in this case as of yet for those very findings of fact to be set forth.
But we
Thank you.
do,
So you want to ask that?
no,
one?
it's fine.
Okay, thank you.
Thank you, Your Honors.
Your Honor, if I may address the points that were made. Certainly at the time, nobody saw this, neither party saw this as merely an interim order. Mr. Beta himself, and this is in the record, RA 312, he spoke of, they're relevant to the issue of the management of the business that at default Ms. Hart owns. This is not an interim order. The court, to one of the points that was raised, did not.
Well, there had to be something more after this order was issued before there was going to be a final judgment of divorce, correct?
That's correct. And this order that we're appealing here does speak of an inquest, but it talks of a very limited inquest, limited to two issues. The dissipation.
Which you had this, have since had this inquest.
We have, Your Honor, and that inquest was cabined and to those two issues. Otherwise, everything else in this order, for purposes of the inquest, was law of the case, which is improper because it's law of the case based on a determination that does not have any findings of fact.
What were the two issues that you say were left for the inquest?
Yes, it's on page A6 and it's sections D and E. And it talks of dissipation in D, and E is concerned with attorney's fees and other expenses spent by Ms. Hart. Everything else was determined.
But so the other distribution of the marital assets were already determined in this order?
As per this order, correct, Your Honor, yes. And
At the inquest, were there any other issues that were determined outside of the two that were listed here?
I was not at the inquest for all of the dates. As I understand it, no. Those are the two issues that were at the inquest. And, you know, it's remarkable because we had a trial in the Delaware Chancery Court that found that Ms. Hart, in fact, is not entitled to 50% of FHI. And it was 2 days of hearing, there was evidence, there were witnesses, and yet in this decision, none of that is reflected, none of that is grappled with. Thank you.
Thank you. Kasserer v. Gottlieb. Ready?
Thank you, Your Honor. John Rockenbach on behalf of the defendant's appellants. The statute of fraud bars these claims for two main reasons. The first is
Can you speak into the microphone?
that the Supreme Court, at the beginning of its decision, stated that the complaint alleged an oral agreement to purchase a piece of Manhattan real estate. That should have been the end of the case. An oral agreement to purchase real estate is the classic example of what is barred by the statute of frauds, so the case should have been dismissed. Now, the court below suggested that discovery was needed, but the complaint itself contains everything we need to know that the statute of frauds defense will prevail. In paragraphs 19 through 23, it plainly alleges an agreement to purchase real estate. And in paragraphs 56 and 62, it plainly alleges that the agreement was an oral one.
But even in the context of that, weren't there a lot of terms of the agreement that were not in the agreement?
Yeah, so
Or the proposed agreement?
yes, the complaint just says that the parties would agree to purchase some properties under some terms at some later date.
So that sounds more like what we say is an agreement to agree, not necessarily an
That is absolutely right, Your Honor, and you know we've briefed that issue extensively. That's another reason to grant to reverse in this case. But
If we reach that reason, we don't need to go to the other.
that's
argument,
right, Your Honor.
right?
So basically, the structure of our argument is there's not a definite agreement here. It's just a proposed agreement to agree. But if there is an agreement here, it is plainly one that is barred by the statute of frauds. And the second main reason that it's barred by the statute of frauds is Section 501, Subdivision 10, which says that agreements to pay compensation for negotiation services in the purchase of a real estate piece of real estate are also covered by the statute of frauds. Here, all that he says is that he's entitled to fees in exchange for finding investors, and a finder's fee is the classic example of what that provision is supposed to cover.
And what about the unjust enrichment? Has plaintiff set forth enough to sustain the unjust enrichment cause of action, assuming that we find that there is no contract?
So that is also going to be barred by the statute of frauds. You can't use an unjust enrichment claim to get around the statute of frauds. And in Chandler v. Roberts, this
We
court
have
held-
unjust enrichment, quasi-contractual claims when we don't have a good contract or an enforceable contract, then we have the standards that might make it a case that allows for unjust enrichment so that somebody isn't unjustly enriched for something that they have done. So why isn't that cause of action at least a possibility at this stage of the game?
Well, in Chandler v. Roberts, it specifically said that claims or contracts about how, under the terms that parties will acquire property are also barred by the statute of frauds. So if you say, we're all going to contribute to the deposit in this way, that is also barred by the statute of frauds. We're not contesting that he might have a status as some sort of investor in this entity. But in terms of a claim for the deposit, that would also be barred by the statute of frauds.
Well, I know that the respondent is, claiming that this agreement really just focused on, interest in an entity, right? That manages but does not own any interest, in property. It's the subsidiary that owns the real estate. So that's why it's out the statute of
Right,
frauds.
but-
What's your, response?
Plenty of cases in this state show that indirect interest in property are still interest in property under the statute of frauds. This court has held that an entity that both owns and has as its sole asset income related to a piece of real property is barred by the statute of frauds. Here, just because the LLCs are alleged to be divided in a slightly different way, where one manages and receives fees, that doesn't mean that it's not an interest in real property. The only value that this entity is alleged to have had is a right to receive fees that are related to the piece of real property. The LLC is named after the piece of real property. The types of fees that they are alleging they're entitled to receive are the kinds of fees that an owner of real property would get. There are promotion fees, financing fees, equity fees. You can't just circumvent the statute of frauds by alleging a complex commercial relationship. Here we look at what it actually takes.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Douglas Siegel. I represent the plaintiff respondents. At the preliminary level, in order to fit for the statute of frauds to apply, you have to fit within the statute of frauds.
Counsel, what were the precise terms of the agreement here? What was agreed to?
Precise terms were that there were three individuals. One of them was Isaac Kasira, the respondent. Each of the individuals would find 1/3 of the financing, and in exchange, they would each have 1/3 of the manager of the entity. They would not have an interest in real estate, either direct or indirect. In other words, if a dollar came into the real estate, it came in from rents, the manager doesn't get that. The investors get it. The manager does not own any interest in the real estate. For example, if the entity issues a K1 to its partner, none of the manager does not get a K1.
Was the entity identified in the oral contract?
Was the entity identified in the oral contract? The entity wasn't formed yet. They said, we're going to form an entity. They're going to form an entity, but that entity was...
Isn't that an important term that's missing from the agreement in terms of there being an entity?
The name of the entity?
No, not the name of the entity, the formation of the entity.
Of course, well, they said we're going to form an entity and each of us would have 1/3 of it.
And where was it going to be formed? When was it going to be formed?
It was in New York, I believe it was...
No, when?
Immediately. Immediately, they said it was July 2022, they're negotiating a contract, and we have to sign this contract, and they formed it immediately. It wasn't formed in the future. In other words, and this brings us to the other point
The
raised.
contract is silent about that, as well as, when the purchase would take place. A lot of missing gaps.
Not at all. Respectfully, Your Honor, not at all. It should be assumed that everything is done immediately. If you had a situation where things were contemplated in the distant future, that's one thing. But if I say, for example, let's go out to lunch, does that mean, well, when are we going to go out for lunch? It means we're going out for lunch right now.
That's not a contract, right? That you haven't contracted to take us out to lunch, right? By saying, let's go out to lunch.
I say, yes, let's go out to lunch. It means we're going right now. If we have an agreement that we're going to buy that building, we're buying that building right now. And that's what happened.
Did the oral contract identify the property or properties?
Sorry?
Did the oral contract identify the property or properties to be?
Absolutely. Absolutely. There were 5 or 6 contracts, and it's in the record, and it was identified. And they said, we have this possibility to buy this. We're negotiating to buy the properties now, to sign the contracts now. Let's form an entity now, to sign the contract now. Each of us will form an entity, 1/3 in this interest in the entity now. So all of the important points they addressed, whether it's going to be formed in an hour or an hour and a half, it's irrelevant. It was going to be formed within a day. It was going to be formed immediately.
Obviously it wasn't, but can you have this type of an agreement to purchase real property I mean, isn't it subject to a statute of frauds
Respectfully, Your Honor,
defense?
absolutely not. Unlike what appellants say, it's not, the statute of frauds doesn't bar agreements concerning the purchase of real estate, which is their language, not more. What it says is a contract to devise real estate or any interest therein or right with reference therein is void. It has to fit within one of those things for it to apply. And this doesn't fit within that. It's not a contract to devise real estate. It's not an interest therein. It's an interest in an entity that was going to manage a different entity.
How about 5-701?
Thank you, Your Honor. I'm happy you brought that up. If you look at 5-701, that does talk about a sale of a business. But if you look at the last clause, which is completely ignored by the appellants, it's when it talks about the sale of stock in a corporation, it talks about the sale of a majority of the voting stock of interest in the corporation. That's a direct quotation. Majority of the voting stock, not a third of an interest. If they were right, then any oral agreement to sell any interest in an LLC or in a corporation would be void by the statute of frauds. But it doesn't say that. The fact that the statute specifically uses the word majority means that the sale of a minority interest in an entity is not barred by 701. And
Are your friends correct that if your contract claim was barred by the statute of frauds, that your unjust enrichment claim would necessarily be barred?
absolutely not, because they're two separate agreements. One agreement talks about a third of the interest in the manager, and then there's a separate agreement where they say, well, we're $5 million short, each of us give $1.6 million. So whether or not the statute of frauds bars the claim for an interest of the manager, there's still a separate claim, which is, I lent you $1.6 million, you're not allowed to keep it.
So the first and second cause of action relate to the interest in the
The
manager.
manager, correct.
Third cause of action for unjust enrichment seeks the return of the
Correct.
client's investment.
Otherwise, my guy's out of $1.6 million, and what does he have in return? Nothing.
Thank you.
Thank you, Your Honors.
Thank you, Your Honors. On the last point, we can see that he has an investment interest in the property. That's the relief that he has. But he can't bring the unjust enrichment claim because it's still dictating the terms under which the parties would purchase the property. The agreement alleged in the complaint doesn't specify the properties, and it also doesn't include a number of material terms that are required when you are going to form an entity under New York law. So it is missing many important terms. On the 50110, it covers more than simply the sale of a business. It specifically says the purchase or sale of any real estate property. And so that the provisions about the majority of a stock, that is not relevant to our claim there.
Anything else?
I'm sorry, sir. What is the strongest authority you have for the proposition that where the statute of frauds bars a breach of contract action, no unjust enrichment claim lies?
Sorry, I'm not sure I have that in front of me. But the Kamalov v. Siegel case, I think, is our best one.
I'm sorry?
Kamalov v. Siegel, that's 985 NYS 2nd 411.
Thank you.
Thank you.
People v. Rashid Davis.
May it please the court, and good afternoon. Daniel Schumeister from the Office of the Appellate Defender on behalf of Mr. Rashid Davis. The summary denial of Mr. Rashid Davis's suppression motion should be reversed and a hearing should be ordered. The motion papers established standing.
With regard to the standing issue and the assertion of Mr. Davis being an overnight guest, that was raised in a motion to renew. That wasn't raised in your initial motion, right?
The overnight guest standing issue was raised in the initial motion, Your Honor, and in any event, the renewal motion was taken up by the court below and decided, and so it is therefore before this court on appeal as well. And on this issue of standing, the Supreme Court's decision in Alston, this is a rare case where the Supreme Court's decision really does speak directly to the facts in front of this panel. There, the Supreme Court held that an overnight guest has standing to challenge a Fourth Amendment violation. And here, Mr. Davis was an invited overnight guest at an apartment in Manhattan in a residence, and he therefore has
What
standing.
information do we have in the record relating to that? What factual allegations were made in the motion about that?
Well, Your Honor, we would point the court to the affirmation in support of the renewal motion, which did describe, I would say, essentially the 5 W's of what occurred here: who, what, when, where, and why. My client and the co-defendant were socializing in Brooklyn. My client was invited over essentially in exchange for driving the co-defendant to the apartment. He was invited to stay over for the night, and his overnight stay was ratified by the resident of that apartment. That is more than sufficient to require a hearing at the very least as to standing. And we would submit to this court also that the case of People versus Delgado, which we cite in our brief, likewise speaks directly to the standard being met here with respect
Counsel,
to...
if we agree with you that there was standing here, with regard to the findings that the court made about there being a protective sweep, why was the court not permitted to make that based on the record before it without a hearing?
The protective sweep was unconstitutional, and the people did not meet their burden in their papers of showing that it was constitutional. Under Maryland v. Bowie, which is the controlling precedent...
But the court, just so that I'm clear about what your response is, the court could make that determination based on the papers. A hearing was not necessary for it, right?
Oh, no, excuse me, Your Honor. A hearing was absolutely necessary. There were not sufficient facts for the court to find that the protective sweep was constitutional. On this merits issue as to the constitutionality, the burden was the prosecution's.
Well, if we look at what happened here, right, there was a shooting. The police respond rather quickly to the shooting and look at a video and see that the perpetrators or people who were involved in the shooting went in and out of that apartment, right?
Well, Your Honor, even if that is the case, the question under Bowie as to the propriety of a protective sweep is whether there are specific facts that the police, the prosecution can point to that show that the police were in danger or that there was danger that potential evidence would be destroyed.
There had been a shooting, correct? And when I think they knocked on the door, the defendant came out and they arrested him. I don't think he had a gun on him, so wouldn't it have been reasonable for them to do a protective sweep to make sure that there was nobody in there with the gun that had been, that they had evidence of, or at least some surveillance tape showing him having just a few moments before?
Well, 2 points, Your Honor. The prosecution below never made those arguments, and that was not a finding made by the court below either. In any event, the key point also is that both people that the police sought had already been arrested. They had been removed from the apartment, and there was no reason that the police or the prosecution provided in the papers and the search warrant affidavit to believe that there was any sort of danger to the police or danger that the firearms evidence might be destroyed. There's nothing here
The
at
fact
all.
of there being a shooting, that doesn't provide information for the court regarding that?
No, Your Honor, that is not sufficient. Actually, in Maryland v. Bowie, the Supreme Court specifically addressed this appeal invocation of the general violence of the crime and said that's not enough. It needs to be specific and it needs to be articulable. And we would point this court to the many cases discussed in our brief and the cases that the prosecution and respondent have discussed, because in those cases, there was very good reason to believe there might have been someone hiding inside. That's really the prototypical situation.
Let's just be clear about this, because as my colleague said, you have the surveillance video, it's the gunfight, they run into the apartment. I believe it was like, what, 2 or 2:30 in the morning when most people are in their apartments, right? So, you know, what was so unreasonable about, you know, doing this protective sweep? I mean, there could have been others in the apartment. There could have been, you know, other weapons in the apartment. So what is so unreasonable about that?
The police and the prosecution never raised those possibilities. There's nothing in the record to suggest there were other people in the apartment who might have done harm to the police officers. There's nothing in the record to suggest that there were other people in the apartment who were going to destroy evidence potentially.
So what you're saying is that even if those issues were in fact there, there needed to be a hearing to flesh out whether that was the case, rather than deciding if there's not enough on the record to make that determination that the court made.
Absolutely, Your Honor. The issue here is that this was a summary denial because the lower court did not even provide Mr. Davis with the suppression hearing that was required, because the papers made enough of a showing certainly to require a full factual hearing for the court to determine what in fact had occurred and determine the legality of everything that went on that evening.
Thank you.
Thank you very much.
May it please the court, Alex King for the people. Defendant engaged in a vicious gun battle, then hid in his fellow shooters.
Counsel, did the papers have enough of a factual showing to establish the constitutionality of the protective sweep? And if so, what in the papers?
The papers had more than enough. The police knew from the surveillance footage they had just watched that there had been this vicious gunfight on a residential street, followed immediately by a flight into apartment 1C, followed then by these arrests of the two shooters without a recovery of guns on their persons. The police had a legitimate reason to be concerned about the presence of a person or persons who could pose a safety threat inside the apartment. The protective sweep doctrine did not require...
But just to be clear, the police already had the two people on the surveillance video in custody, right?
They did, but they did not have the guns. If they had recovered the guns, this would be a different case.
And they didn't know whether or not there was a third or fourth person in the apartment, anyone else in the apartment.
That's correct. And as it happened, the police found out when they entered, if they didn't know immediately before, that there were 3 young children in this apartment. The police...
That may be, but the question is, was there enough in the papers for the court to make that determination without a hearing?
Yes, there was enough in the papers for the reasons that I stated earlier. We have this...
Is it enough not to know that there's someone else in that apartment?
Yes, it is enough, because the crux of the protective sweep doctrine is not the police knowing for certain that somebody is there. It's to make sure that nobody is there who can do harm to the police, do harm to somebody else, or destroy evidence. So the police could not go into the apartment and open up the tenant's desk drawers, look in places that were not large enough to conceal a person. But the police did not do that. They simply walked through the apartment where they saw in plain view the guns that they were looking for. The police did exactly what we would want them to do.
Well, were they looking for the guns, or were they looking for someone who might hurt them?
They're looking for both. I mean, part of the reason that it made sense and was reasonable for them to enter the apartment is because they had not recovered these guns. If they had recovered the guns in the hallway or out on the street where the shootout had transpired, this would be a different case.
Do you want to address the arguments about standing and being an overnight guest?
I do. So by defendant's own allegations, he was nothing more than a casual visitor to this apartment. The suppression court was not required to ignore the obvious, which is the defendant was using this apartment as a temporary hideout. He showed up in the middle of the night after a vicious gun battle. He had no previous connection to the householder. He was there for all of 77 minutes.
The co-defendant invited him. The co-defendant invited him because he was residing in a shelter. The co-defendant invited him. It was, the apartment belonged to Flowers, was advised, she accepted. What more do you need?
The defendant could have alleged much more. He could have
Such
alleged,
as?
he could have alleged that he had, for instance, been there at any time in the past before he.
But is that
engaged-
necessary to get a hearing on the issue of standing?
So this is a totality of the circumstances inquiry. It's not one factor is dispositive, and based on what defendant himself alleged, even crediting it as true, it showed that he
We
was
have to
nothing
credit
more.
that it's true. You know, like I said, we have these allegations regarding the invitation, the acceptance by the owner of the apartment. The defendant agreed, claimed that he went to park his car and returned to spend the night. What else do you need?
That's not enough. Simply showing up at somebody's apartment, even if you're invited by somebody else, that's not enough to make you an overnight guest. The Court of Appeals has told us that there are a number of factors you must look at. Not a single one is dispositive, but you can look at, did this person have a key? No allegation. Did he store a change of clothes there? No such allegation. Had he ever been there before? No such allegation. We can credit all of these, as we should in this procedural posture, and say that he was nothing more still than a casual visitor. It was not an abuse of discretion for the suppression court to so hold here. If there are no further questions, we ask that you affirm. Thank you.
All right.
Quickly, Your Honors, just very quickly, this is not a question of discretion. This is a question of law. This is entirely clear from 71060 sub 3. Now, moving on to the merits issue as to the constitutionality, the respondent's view of this case would essentially turn Bowie and the other cases like that upside down. As they propose here, as long as the police have not yet found the evidence, then you can intrude into anyone's private residence.
No, that's not what they're saying. They're saying the place where shooters have just retreated from is a place where you can do a protective sweep. It's not just any apartment that was, you know, available to them.
Well, Your Honor, the police and the prosecution do need to point to specific articulable facts in the record that are going to show why there was danger to the police officers and why there was danger to the evidence.
Well, part of their argument is that because the guns had not been retrieved and that was the apartment where they saw the individuals from the surveillance tape who had just been involved in a gun battle retreat to.
Yes, Your Honor, but the police had no reason to believe there was anyone else in there who would have threatened them with firearm.
What's the test, though, or the standard or the scope of a protective sweep? Because as I read Maryland versus Buret, it's the people have to articulate facts which, taken together with the reasonable inferences from the facts, would warn a reasonably prudent officer in believing that the area to be swept harbors an individual posing a danger.
Exactly, Your Honor. They needed to believe that the apartment in general harbored an individual posing danger to them. Here, as the search warrant affidavit puts it, they had arrested Mr. Robinson, the co-defendant, at the threshold. Frankly, it's not clear. Again, a reason that we really need a hearing here. And then they entered after both.
Why couldn't it have been reasonable for them to have the officers to have thought that there could possibly have been another person inside the apartment with the guns that were involved in the shooting, but that had not been arrested with had not been on the defendants when they were arrested, the defendant and the co-defendant, I'm sorry.
Well, it was the prosecution and the police's burden to explain why that could have been the case, and they provided no reason to believe there was anyone else in there. All we had in the record...
And there's no reason in the record to make that determination. A hearing would have been where you could flesh that out.
Exactly, Your Honor. A hearing was needed.
Thank you.
Very much.
Moreno Santos v. Real Builders.
Good afternoon, Your Honors. May it please the court. My name is Michael Peters with the law firm of Siegel and Coonerty. We're the attorneys for the plaintiffs' appellants, Jairo Moreno Santos and his wife, Diana Gongoro. Plaintiff in this case fell off of a ladder on a construction site when the ladder slid out from underneath him. The ladder in question was the top half of an extension ladder, which had been separated into two pieces and lacked rubber feet. The plaintiffs claim that the defendants are liable pursuant to Labor Law 240 subsection 1, as well as Labor Law 241.6 and 200. The lower court initially found that on this fact pattern, the plaintiff had made a prima facie showing that the defendant failed to provide him with the proper safety equipment to protect him from an elevation-related hazard. However, the lower court found that the defendants had raised a triable issue of fact based upon the plaintiff's boss's testimony that there were other ladders available for his use on the site. And this is really the central dispute on this appeal, is whether there were other ladders available for the plaintiff's use and whether he chose for no good reason not to use them. The seminal case for this defense is a Court of Appeals case called Gallagher versus the New York Post. And that case makes very clear that in order to raise an issue of fact about whether the plaintiff is the sole proximate cause of the accident for failure to use alternative safety devices, they have to show two things. Number one, they have to show that the alternative safety device was, quote, readily available to the plaintiff at the time of his accident, and two, that the plaintiff knew he was expected to use that alternative safety device, but chose for no good reason not to do so. And in this case, it's plaintiff's position that the defendant failed to show either of those two prongs, and therefore the lower court erred in finding an issue of fact about whether he was the sole proximate.
Because we only have Fagan's testimony, am I correct? Fagan?
Correct.
I'm almost done. And certainly, I don't believe that Fagan conclusively established that, other ladders were available, right? I mean, because we don't have any testimony from the foreman who failed to provide the ladder, or even the co-worker who was working on an A-frame ladder, right?
That's correct, Your Honor. So Mr. Fagan, the plaintiff's boss, testified that the practice on this job site, the custom and practice on this job site, was that the foreman would have given him one of the ladders from the shanty. And the plaintiff,
The shanty was locked, right? There was testimony that the shanty was locked, and the plaintiff was not able to get, he didn't have a key, he couldn't get entrance to the shanty, so somebody would have had to provide him a ladder.
Correct. Mr. Fagan conceded that during the working day, the shanty would have been locked, and the only person with the key would have been the foreman, Mr. Lohano. And it was undisputed on the record that the plaintiff repeatedly asked Mr. Lohano to provide him with a ladder, and in response, instead of retrieving a ladder from the shanty for him, Mr. Lohano's response was, well, just go up to the roof and use whatever you can find up there. And the plaintiff repeatedly testified that he not only asked Mr. Lohano to provide him with a ladder, but also that he conducted searches of multiple floors of the job site for alternative ladders, but that the only one he could find at the time was the top half of an extension ladder, which lacked rubber feet. And that's the ladder that's the only ladder that was available for his use at the time of the accident, and the ladder that he ultimately fell from.
And then we also have an acknowledgement, right, from the defendants that type of ladder would be an inadequate safy device, right?
Correct. I don't think it's disputed by the defendants that this was an inadequate ladder, unsafe ladder. This is a ladder that is separated into two pieces, and there are numerous cases where plaintiff has been granted summary judgment on those grounds. And the fact that the ladder was both locked in the shanty and that he repeatedly asked his foreman to retrieve it, but it was not provided to him, makes it very clear that the ladder, that there were no other ladders that were, quote, available for the plaintiff's use at the time of the accident. And so therefore, it's our position that he was required to use that ladder and was not the sole proximate cause of the accident. The other aspect of it is they also have to show that the plaintiff, for no good reason, chose not to use the other available ladder. And of course, obviously, there's no way they can show that if they fail to show that there were other ladders available for his use. In our brief, we cite to numerous cases of this court, which has granted summary judgment to plaintiff in similar circumstances. Among them is a case called Linares versus Massachusetts Mutual Life, which was decided by this court in 2024, as well as DeLeo versus 95th Owner, and Latch versus LICC Realty, both decided in the year 2024 as well. Looks like my time is up. Thank you very much.
It is. Thank you. But you have time on rebuttal.
Good afternoon, Your Honors. May it please the Court. London Zographagus for defendants, third-party plaintiffs, respondents, appellants, real builders, and MLK Plaza Housing Development Fund Company. First, I would like to address one of the points that Plaintiff's Counsel has made with respect to the evidence before Your Honors. The evidence
through Mr. Moreno Santos's deposition testimony does not indicate that he repeatedly asked for the foreman to go to the shanty and obtain a ladder for his use. Rather, it shows that he indicated there were no ladders. He located a ladder. That ladder was eventually taken from him by an individual from another trade. He went back to the foreman to note to the foreman that the ladder was removed, and the foreman told him to locate and use a ladder. The foreman did not tell him to complete the work however he could. There was no general statement to go ahead and use.
But you do concede that this was not an adequate safety device for the plaintiff to use to do his work, right?
Yes, Your Honor, we do concede that. I believe the deposition testimony of both Mr. Bernard Fagan, the representative of Real Builders, also indicate that. And plaintiff's own admission was that he knew that this top half of the extension ladder was not proper to use for the performance of his work. And in fact, when he had approached the foreman regarding obtaining another ladder, he was allegedly aware that there was this top half of the extension ladder, and while being aware of it, did not mention it to the foreman, did not indicate his intended use of it, and when he performed a search, as he testified to, he did not return to the foreman and say, I couldn't locate a ladder. May you please go to the shanty and provide me the ladder so I can complete my work.
You know, was there any evidence that there was an available ladder in the shanty and plaintiff chose not to use it?
Mr. Bernard Fagan's testimony does provide that there was more than 10 ladders of different varieties that were available in the shanty. The shanty is where the employees of North-South Masonry would
There's
go.
evidence that that was available to the plaintiff at the time of this accident?
They were, per Mr. Bernard Fagan's deposition testimony, there were more than 10 ladders available in the shanty. The shanty
It
was
was locked. It was locked, right? The shanty was locked.
The shanty was locked, and the foreman on site that Mr. Moreno Santos did speak with on the date of loss.
So those ladders were not available to the plaintiff at the time of the accident.
There is also testimony that at the time of the accident, or near the time of the accident, a coworker was in fact also using an A-frame ladder to perform his work. And in fact,
Well, I was asking you about those multiple ladders that you said were in the shanty. Were they available to the plaintiff at the time of the accident, given that the shanty was locked?
per the testimony of Mr. Bernard Fagan, the workers were able to return to the shanty at any point during the workday to obtain the necessary materials. They would speak with the foreman would unlock the shanty to provide those materials. And just with respect to the contractual indemnification claim, there are two indemnification provisions contained in the contractual documents between Real Builders, the general contractor, and North-South Masonry, a masonry subcontractor. One of those indemnification provisions contains no requirement or finding of negligence on North-South Masonry's part, and the other indemnification provision, while it does require negligence on the part of North-South Masonry, there is indication in the record that there is at least some negligence attributable to North-South Masonry, as their foreman provided the instructions to the plaintiff. The contractual documents require that they provide the tools, equipment for North-South employees, as well as they were responsible for directing and controlling the work of North-South employees. The record does not establish that in any way, shape, or form that Real Builders or MLK, HP MLK were negligent, and if any finding of negligence was made, that would simply be statutory or vicarious. We also request that the court's decision with respect to Plaintiff's Labor Law 241-6 claims, as well as the Labor Law 200 and common law negligence claims against our client be dismissed. With respect to the Labor Law 241-6, it is required that the specific qualifying subsections of those industrial code sections, and it looks like my time's up.
Finish that sentence.
In those sections be pleaded in the complaint or the bill of particulars. In this case, that was not done so. And with respect to two of the subsections, I believe it's 1.7 and 1.17, that was not discussed in either the motion for summary judgment opposition or the respondent's brief.
Thank you.
Thank you, Your Honor.
May it please the court, Frank Wennick from Amity Demers and McManus for respondent North-South. Real Builder's attorney just said that there were 2 indemnity provisions. Well, that is true. One was contractual indemnity and the other was for insurance. The insurance provision does not give you contractual indemnity. And in fact, what they didn't do was have any evidence that they had asked for coverage under that, which was the stronger provision, and therefore they haven't shown that they're even entitled to that. But what's funny about this is that they were complaining that we didn't raise the issue of condition precedent before appeal. And while that is correct, it was on the face of the record, and it would have to have been addressed if it was raised at the right time. The only defense they sort of have to this is laches, that they weren't able to marshal evidence on this issue. There's no marshaling that needs to be done. They either did or did not request mediation as the contract requires. There is nothing in the record that shows that they made any such request.
But in terms of the alternative dispute resolution provisions, isn't our case law that if you delay and participate for years in the litigation, including filing of dispositive motions, that you lose your right to assert arbitration at that stage of the litigation?
Well, the parties didn't raise that issue at all, and what I say with regard to this one is
This is also an issue that I think you didn't raise until the appeals, so.
No, that's correct, but I'm just, if they argue that I did something that wasn't proper, then I can say that they did the same thing.
Fair enough.
You have a stronger argument?
Yeah, but
Discuss, because, the third-party action commenced in 2019, it's 6 years later, and first time on appeal, so maybe there's something stronger that you can focus on.
I'm not disagreeing with that. I just needed to raise it, but what I'm talking about here would be prejudicial delay. And so with regard to this case, I know that it has gone on, but there is no prejudice that would have caused them in their defense of the case. I'm only saying that they neglected to do this. We should have done it earlier. We didn't do it earlier, but it was something that is on the face of the record and therefore may be raised. And to the extent that they cannot show any prejudice from the delay.
Isn't the protracted litigation here the prejudice itself?
No, I don't think so, because you're talking about the what their rights are and what my rights are under the contract. And so the fact that litigation has gone on is unfortunate, but it's not that anything needs to be duplicated as a result of that. It merely takes those
It's not just unfortunate, it was expensive.
It was, sorry?
It's okay.
What about the claims that the defendants have for contractual indemnification against your client?
Well,
they're moving for at least conditional summary judgment on the contractual indemnification, correct?
Yes. But to the extent that they bear some liability on this, it creates issues of fact that would preclude even conditional indemnification. Their liability lies with the fact that there was on the construction site this ladder that we all agree was dangerous to use. They have 15 people on site doing work. They've got a site safety manager that goes around constantly looking for dangerous conditions. And they did not make any attempt to show that they had no actual or constructive notice of this ladder. And so in that regard, they didn't satisfy their prima facie burden to have their motion granted.
Anything else?
I don't have anything else unless you have questions.
Nope. Thank you.
I just want to very briefly address counsel's point about, well, the plaintiff could have spoken to the foreman to retrieve a ladder from the lock shanty. There was extensive testimony about this, and in page 8 of my reply brief, I quote several portions of the plaintiff's testimony. He testified that his supervisor, quote, told him to use what was there and to, quote, take whatever was available, and, quote, go and find a ladder to work with. Upon telling Mr. Lojano, the foreman, that the ladder he was using earlier in the day had been taken away by another trade, the response given was, quote, there must be ladders there, right? Or do you want me to go and place the blocks down by myself? It's clear in this situation that there were multiple opportunities for the foreman to provide the plaintiff with an alternative ladder, and despite the plaintiff's efforts, they failed to do so, and that's the basis for why plaintiff should win summary judgment in this case. Thank you very much.
Thank you.
And Your Honors, very briefly, regarding the contractual indemnification, there are two provisions. Third-party defendant states that the Section 1 provision contained in the subcontract insurance agreement is merely limited to insurance. That provision itself makes no such limitation. So respectfully, that provision is a more expanded provision. It expands the class of indemnities. And regarding conditional indemnification, which we are seeking at minimum, because in this case, there's no dispute as to whether this arose out of the contracted for work. Mr. Moreno-Santos was an employee performing work on behalf of North-South Masonry at the time of the accident. The only potential issue which a jury could later determine is the apportionment of liability, if any. And there is no circumstance in which North-South Masonry wouldn't be liable to our client for something. With respect to the delayed argument regarding a failure to comply with a condition precedent, the cases relied upon in North-South Masonry's respondents' brief deal with arguments that were brought up at some point prior to the appeal, whether that be in opposition to a motion and just simply not raised in the answer, but they were brought up at some point prior. And third-party defendants' arguments with respect to, there's no prejudice, there's no marshaling of evidence. The record doesn't contain evidence regarding this alleged failure of a contingent precedent because that wasn't put forth to the parties. There were no questions asked at the deposition regarding this because that wasn't one of the claims that we were facing. As Your Honors pointed out, this argument is being made several years later. Thank you, Your Honors.
Thank you. McIntyre v. FNY GP LLC.
May it please the court, David Gillette, Miller Levy and Associates for Plaintiff Appellant William McIntyre. It is respectfully submitted that the motion court erred when it held that operating agreement section 9.4 is a conditional limitation and a employee choice doctrine provision. That was contrary to controlling Delaware Supreme Court precedent. In the case of Thompson Street Capital Partners against Sonova, the court said that a conditional limitation must be, quote, clearly and unequivocally expressed. There's no clear and unequivocal expression of a conditional limitation or a forfeiture for compensation in section 9.04. In Cantor Fitzgerald against Ainsley, the court said that the employee choice doctrine assumes that the employee can make, quote, an informed choice between contingent compensation and going to work for a competitor. There's nothing in section 9.04 that would enable Mr. McIntyre or any other member of First New York to make an informed choice about whether to forfeit contingent compensation or go to work for a competitor. And the Delaware Supreme Court—
And is that taking the agreement as a whole, or are you just looking at specific sections?
Oh, no, Justice Michael, I am looking at the agreement as a whole, and in a moment, I will show the court why section 9.04 cannot be, as a conditional limitation of forfeiture for compensation, can't be reconciled with the other provisions of the operating agreement. But I did want to touch on the point that contra proferentum applies in Delaware, according to the Court of Appeals, the Supreme Court, so that to the extent 9.04 could be considered ambiguous, the ambiguity would have to be resolved in McIntyre's favor. Now, turning to your point, Section 9.04 can't be reconciled with the other provisions of the operating agreement if it's a conditional limitation and a forfeiture for compensation. First, we'll look at Section 12.02, which governs restrictive covenants. There's 11 subparts in Section 12.02. They're very detailed. Nothing comes close to a conditional limitation or a forfeiture for compensation. 12.02K talks about breach, money damages, and injunctive relief. None of those provisions are consistent with forfeiture for compensation or with a conditional limitation. Section 12.02A directly talks about, quote, total forfeiture. It's the only provision in the entire operating agreement that talks about total forfeiture. And it provides for total forfeiture, let's see if I can get this right, in the event of violation of law, code, regulation, policy, guideline, or statement. It says nothing about violation of any of the other provisions in Section 12.02. It says nothing about if an employee is terminated for cause. So it doesn't apply. If we look at what the definition of cause is, definition of cause does include engaging in violation of the restrictive covenant. In the event of termination for cause, the executive committee has the discretion to declare unvested capital forfeited pursuant to Section 5.03 C19 and 5.03 C20A and B. The executive committee wouldn't have authority to declare compensation partially forfeited if it had already been completely forfeited pursuant to Section 9.04.
I just want to go back. Is it your contention that Section 904 is a non-compete?
No, Your Honor. The non-compete is in Section 12.02.
Okay.
Section 9.04 provides that First New York is obligated to return a trader's capital account within a year of when the trader leaves, but can be returned earlier unless the trader has engaged in fraud, willful misconduct, breach of the agreement, or violation of regulatory violation.
So that clause doesn't apply to the whole section. It only applies to that particular point, as far as your reading goes, about the early return of the compensation?
I read 9.04 as affirmatively obligating First New York to return the capital within a year, and as providing that it can be returned by the managing member in less than a year, provided those conditions are met. And that affords the managing member an opportunity under 6.05B to decide whether there are damages that need to be offset against the capital account, and it also enables the executive committee.
So your reading of it in that way would mean that if those things occurred, if there was some fraud, some willful misconduct, or breach of the agreement, that there would still be a requirement to return the compensation within a year?
Yes, Justice Michael.
Okay, you mentioned 605, but I don't see how that's applicable because that section addresses the penalty for recklessness, gross negligence, when that conduct is based on trading losses, and that's not what we have here. So how is that even applicable?
Well, the point is that, Your Honor, when the executive, when the managing member is looking at Section 6.05 and trying to decide whether or not there's going to be an offset, if all the money has already been forfeited pursuant to Section 9.04, there's no money to offset. So it takes the teeth out of that provision. It renders it null. And it also renders null the provisions in Section 5.03 that let the executive committee in their discretion determine whether or not to declare unvested capital forfeit. If all capital is forfeit pursuant to Section 9.04, there's no determination for them to make.
Yeah, I mean, once again, because we're talking about current cumulative accrued loss, losses from a member's trading activity. That's not what we have here. And why can't the Section 904 be read as, counsel says?
9.04 can't be read as a conditional limitation and under the employee choice, a forfeiture for compensation provision, because controlling Court of Appeals, Supreme Court, Delaware cases tell us that a conditional limitation needs to be clearly and unequivocally expressed under Thompson, and that the employee's choice doctrine assumes that the employee can make an informed choice under Kent or Fitzgerald against Ainsley. There are all these other provisions in the operating agreement that specifically provide for forfeiture. There are half a dozen provisions that call for partial forfeiture. There's the one provision that I cited, 12.02a, that calls for a total forfeiture, using the words total forfeiture. There's no reason why we should imply a total forfeiture in section 9.04 when it doesn't say total forfeiture.
So it has to say that.
It
That's not
doesn't
what the
have
case
to
law
say
says.
that, but that is one of the reasons that interpretation is inconsistent with the operating agreement as a whole.
All right, thank you.
Good afternoon, Your Honors. Adam Oppenheim, on behalf of Respondents First New York GP LLC and FNY Holdings LLC. Most of the arguments in Appellant's brief read like they're addressing a motion to dismiss. Appellant argues that the words on the page should be read differently than urged by the court below, and this ignores a fundamental defect in this argument. This is a motion for summary judgment. The record is closed, and the words on the page are not ambiguous under the law because only one rational interpretation of the words on the page emerged from discovery. For those words to be deemed ambiguous, it must mean more than they are somewhat confusing or could have been written better. Appellant has an obligation to put forth a rational alternative explanation of the words on the page. I believe this court got right to it. The appellant's interpretation of the words on the page mean that if I violate the law, if I commit fraud, if I violate anything in the agreement, I still get all my money back within the year. And this was the irrational conclusion that the court observed below and said meant it cannot possibly be the way the parties meant for this agreement to be interpreted. But there's more, right? Because we got a record, and in that record, we know what appellant was going to say because appellant was deposed, and appellant said he never had another understanding of the words on the page, and that matters too. If you sent this back down to the lower court, there's no record on which they could rely to support an alternative interpretation of the words on the page. Briefly, this is the language at issue. Section 904 says that FNY shall distribute an amount equal to the withdrawing member's liquidating share no earlier than the 1-year anniversary of the withdrawal date, but may be made earlier in the sole discretion of the managing member in the absence of fraud, willful misconduct, breach, or regulatory infraction. So this whole case is about whether or not the phrase in the absence of modifies the entire distribution. If it does, then the trial court was correct and appellant should lose. If it modifies only the preceding clause, the early distribution of the liquidating share, then appellant should win. But appellant cannot win because appellant is foreclosed by the record, which, as I mentioned, includes notably his own deposition testimony. Appellant testified that he never had a different understanding of the words on the page and that he attempted to hide his breach from his employer, which is a weird thing to do if you don't think there are financial repercussions of your actions.
What exactly did the appellant say as far as your argument is concerned?
I'm sorry, I don't understand exactly. You mean in the sense of how he tried to hide his...
Right.
Okay. So...
Because what you're saying is not the exact words quoted from his deposition, right?
Well, it's pretty close, and they're in the record, and I did cite them. I have them here, and you can look on R278 to 81. You can look at R273, 285, 296, 307 to 308, 310 to 311, and 313 to 314. I'll summarize them briefly if you'll give me just a moment here. Appellant testified that what he did was use someone else's Bloomberg IT to communicate with people from his new job. He couldn't explain why that was the case. He was aware that a former First New York partner worked where he was going to work, and he then decided to cloak his employment there by using someone else's Bloomberg ID. It doesn't make any sense, and it's all on the record. He also testified when he was first presented with the operating agreement in 2015, he knew he did not have to sign it. He was told he could stay a trader. Appellant signed this agreement because he reviewed it and wanted to be a partner. It was his own testimony that he didn't read it carefully. That's not First New York's fault. Even if his lawyers have now thought up a more compelling way to explain the words on the page, it doesn't matter because this is not a motion to dismiss. The factual record already establishes that a rational alternative understanding on the page does not exist. This is Amgen Holdings v. Remco, which, by the way, is that's the Delaware case. It says the same thing we say in New York under RM Realty Holdings. You can't just sit back and say, we could have used an Oxford comma here. That's not enough. Your interpretation has to make sense.
Did they offer any type of alternative, reasonable reading of these relevant provisions? You're saying, you know, for us to consider even.
I mean, I would urge you to ask appellant that question. I don't see anything in this.
Did you
record
see
that
anything in there?
Well, look, this is exactly what the trial court said. What appellant is suggesting is that I can walk in on my last day and say, hey, you know what? I committed fraud, so I guess I got to wait a year for all that money. And that doesn't make sense. It's not rational. Nobody ever testified that that's what they meant. But appellant needs that to win here, because otherwise we don't have to give him a liquidating share. And that's the words on the page. Anything else, Your Honor?
Nope.
Thank you very much for your time.
Your Honor, what my learned adversary overlooks is that there's a whole provision for termination for cause with a capital C, and that's in the record at section on page 452.
We're not talking about termination for cause, right? We're talking about the section where someone leaves and goes to work with another person who used to be a member within the prior 12 months. That's what we're talking about.
Well,
That's specific.
with due respect, Honor, we seem to be talking about two things, and I'll try to address them both. Ms. McIntyre could not leave without repercussions. He's not free to breach the agreement in some flamboyant way without repercussions. There's such a thing as cause. If he's terminated for cause, the executive committee...
But he wasn't terminated, right?
Okay, so he went to work for a competitor. Going to work for a competitor allows the executive committee to determine whether unvested capital is forfeited under section 5.03, 19 and 5.03, 20A. So there are specific provisions that give the executive committee authority to consider that. Also, 7.01B and 7.01C, A, and B give the firm authority to declare unvested capital forfeited, not an entire capital account forfeited. So in terms of, if we're talking about competition and a restrictive covenant, that's a little bit different than talking about whether or not we're dealing with a conditional limitation and the employee choice doctrine. Because if we're looking at this as a restrictive covenant, we have to look at the Delaware authority in Sunder, in which a heightened scrutiny applies to restrictive covenants. And Fortiline...
I don't understand why you keep quoting to these other sections and you're not staying focused on section 9.04 and what your alternative reading of that section is, how it relates to working for a competitor and then seeking your withdrawal.
Your Honor, section 9.04 doesn't actually specifically say anything about going to work for a competitor. What section 9.04 says is that First New York is going to return a capital account within a year, subject to the managing member's right to return it early in the absence of fraud, willful misconduct, breach of this agreement, or regulatory infraction. That doesn't directly say anything about, it doesn't say cause. If it said cause, we would be talking about among the definitions of cause is breach of the restrictive covenants in Article 12. It's not there.
Thank you.
Thank you very much.
Kramer v. Edelstein.
Good afternoon, Your Honors. May it please the Court. Nicole Master-Sinkway for Respondents Majestic Realty and Florence and Michael Edelstein. I promise to be very, very brief. The trial court's decision should really be affirmed for 3 reasons. First, all claims are barred by the statute of limitations. This is the easiest way to resolve the case. Second, the claims are equally barred by the doctrines of res judicata, as several courts have already decided that these claims are frivolous and meritless and have decided on the merits.
Yeah, I mean, this was an eviction, right? 2015.
Yes, Your Honor.
There was an action in 2019, a federal action. Same allegations, right?
Yes, Your Honor.
Dismissed.
Yes, Your Honor.
What else do we need?
My last point is just in connection with the trial court's decision to enjoin the plaintiff from further filing without leave of court. And I think this is really important because there has been a 12-year ongoing litigation against my clients, the rest of the defendants, and also the court has to deal with these claims and spend time, money, and resources that could be allocated otherwise. Therefore, we respectfully request that the trial court's decision in its entirety be affirmed. No further questions.
Thank you so much.
May it please the court, Alec Neiman for defendant respondent Christopher Duval. I concur with everything learned counsel said here today. As you noted, Your Honor, the plaintiff was evicted in August 2021. The only connection my client has to the plaintiff is that he represented the plaintiff's landlord in the eviction proceedings. If there was a justiciable claim arising out of that, if it was legal malpractice, it would have become barred by 2018. If it's fraud, would have become barred by 2021 with the 6-year statute of limitations. My client was lucky enough to have not been a party to all the previous litigation, so there's not a res judicata argument applicable to him. But if you treat this as a legal malpractice claim, it seems the plaintiff is just suing his adversary's attorney years later for simply representing his client. There's no privity. There's also no proximate cause because plaintiff admits that he didn't attend the eviction hearing because he believed it was illegal. So for those reasons, I ask you to affirm the decision.
And then, also there are allegations of violations of various criminal statutes, rules of professional conduct, and there's no private right of action, right?
Right. There's no, I think the only one of those is the federal RICO statute that could create a private right of action that's in the exclusive jurisdiction of federal courts. The rest of them do not create a private right of action. And violations of the professional rules do not either. So I ask that you affirm, Your Honor.
Okay.
May it please the court. Michael Jacobson of the law firm Marshall Dennehy for defendant respondent Lisa Spitale. As stated in our brief, the motion court properly found that Ms. Spitale lacked sufficient contacts with the state such that the court cannot exercise jurisdiction over her under any provision of New York's long-arm statute. Her connection to this case is that she is a court-appointed guardian for plaintiff's now adult daughter in a Pennsylvania proceeding. She lives and practices in Pennsylvania. She's never been barred to practice law in New York. She's never been, or licensed to practice law in New York, never practiced law in New York even. She's a partner of a firm that has a physical practice in Pennsylvania. It's essentially a local firm. They have almost all of their compensation and revenue from representing clients based in Pennsylvania regarding Pennsylvania matters. Based on those reasons, we ask that this court affirms the decision of the lower court. If the court has no further questions, I rest on our brief.
All right. Thank you all. Thank you.
Thank you.
Tecton Builders, LLC, v. 1232 Southern Boulevard, LLC.
Good afternoon, Your Honors. Gerard Honorata from the law firm of Pekar and Abramson. On behalf of the plaintiff, appellant, respondent, Tecton Builders. Your Honors, I'm trying to keep this very brief and put my arguments into 3 categories. The first category goes to the issue of the willful exaggeration of the lien claim. And to that, I say this, Your Honors. We made a mistake, but we did not willfully exaggerate the lien claim.
Where did the $1 million come from?
Yes, Your Judge, I'll tell you exactly where it came from. So when we were preparing our lien claim, it would appear that we included costs that the project did not incur at the time we prepared the initial lien claim. That was comprised of approximately 18 credits totaling $1.1 million.
Shouldn't somebody have looked over these documents a little bit more carefully? I mean, my understanding was that you got terminated, you were terminated from the job, and the very next day you filed this lien.
Your Honor, what happened with respect to that is as follows, and I think that's where the trial court made an error. The trial court makes it sound like we ran to file our lien. But Judge, we started filing, the lien is dated January 4th. So we were in the process of preparing that lien already. We did, however, file a lien on January 5th. But Your Honor, we weren't paid since September of 2016. We had open invoices for October, November, and December.
But so
The last
counsel,
date that your client performed work was January 3rd. And so this 1 million, and I know it's more, I'm just, 1
Yes, Your Honor,
million,
for
right?
round numbers, yes.
It's from January 17th, 2017 through May 5th, 2017, and your client is already off the job.
That is the error, Your Honor. However, after that, Judge, we submitted an initial itemization, but then we submitted an amended itemization. Judge, the amended itemization included approximately $1,494,232 for retainage. That is work that we earned and would do that money.
So you're saying that even though you made a mistake, you never really asked for more than what you were entitled to? You might have gotten the lien a little messed up when you made
Yes,
it.
Your Honor. So basically, Judge,
You didn't ask, it was an exaggeration, it was a mistake.
it wasn't an exaggeration. It was an honest mistake, Judge. And if you put that money back in, I'm entitled to lien for even a higher amount, approximately $7.1 million. There's no question, Judge, that I didn't include the retainage when I should have. There's no question that I put in costs that I shouldn't have, Judge. And yes, I say it's a mistake. And this brings me to my big point. I'm entitled to explain that in a full hearing. And I don't think there's enough here where the court could have found willful intent to deceive anybody.
So let me answer this question, because you said inadvertent, you said it below, you're saying it here. What explanation, I mean, how did it become inadvertent? What's the explanation? Because I haven't heard it.
Judge, when we were preparing the lien claim, we basically brought it down into 3 categories of costs. Those categories were, I believe it was disputed change orders that had yet to be submitted. It was retainage, it was contract balance, okay, that we wrote under our requisitions. And then it was all other work. Judge, this was a cost-plus contract. There are numerous costs that are compiled on a monthly basis to support a requisition, Judge. We simply made a mistake, Judge. That's the best I have to offer, Your Honor.
Yeah, and the reason why is it seems like there's a lot of mistakes because, in the decision, various footnotes talks about other discrepancies with work and for workers who were not even on the site.
Yes, but Judge, I don't know how that relates to the lien claim.
Well, because all of these mistakes, inadvertent, and, once again, no explanation.
But Judge, I would like to bring some things to the attention of the court too, which I think are really important. As the court is aware, there was a Section 38 proceeding for Judge Briganti. Now, Judge Briganti, when we submitted our amended itemized statement, found that we complied with Section 38 of the lien law. But she also found the following. This is a direct quote. Petitioner, meaning 1232, knows which work was paid for and which remains unpaid. That was a finding by Judge Briganti. I would respectfully submit that that cuts against a finding of willfulness and intent to exaggerate. That's my point, Judge. There is not enough here to substantiate an argument that we willfully exaggerated. Did we make a mistake? Yes. But we did not intend to deceive anybody. We stood on this job without getting paid, and they're making it seem like we're the bad actor. And this notion about running to the courthouse, I could have filed my lien claim back in October or November. I really think it's a red herring. It's immaterial to what's happened here.
All right, thank you so much.
Thank you, Your Honor.
Good afternoon, Your Honors. Michael Glansman for the respondent, Cross Appellant 1232 Southern Boulevard, LLC. May it please the court. What I did not hear from counsel what was completely overlooked here, and I'll get to the willfulness in a second, is the fact that this lien and the multiple itemizations that came subsequent to that were falsely verified. Okay, the lien law requires as a prerequisite to maintaining a lien in New York, because it is such a powerful prejudgment remedy that affects property, anyone can do it. I can go into the county clerk and file a lien against any piece of property. This is the protection. They must verify it in a sworn statement. If it is not verified or it is falsely verified, it is void and subject to cancellation.
And how does that relate to the willful exaggeration?
So the first part is any lien that's falsely verified is void. The fact that they didn't check it, there's no dispute here that this was falsely verified. Mr. Gassion, the president of Tecton, blindly signed this verification saying that he reviewed the lien, he was aware of the contents, he checked their accuracy and truthfulness, and then admitted that none of that happened. Had he done that, that's the check on this to make sure that what's there is they're permitted to bill for it. So
One of the key questions here is, because negligence wouldn't cut it for you. So what is, in your view, the legal standard for willful exaggeration under the law?
Sure. There's the cases that are in our brief and that the court cited say that on a motion for summary judgment, willfulness can be found if it's conclusive. And it's conclusive if the movement establishes that the lien includes amounts that there's no question they were not entitled to bill for. Okay, it's not arguable.
So the fact that he argues that they put stuff in that should not have been there, but later they realized that there was other stuff they had left out, and so it was never really exaggerated. The amount was never exaggerated. That does not cut it.
Completely irrelevant to this argument. So if you establish that what's in the lien, it's clear cut, they could not have billed for it. And I think this $1 million that we're talking about, I don't know that it could get more conclusive, right? It's for a period of time after the lien was filed and after they had been kicked off the job for many months.
So could you get to the other issue, which is, I guess that's what your
Sure, my
cross appeal with the second part, and because that one I find really somewhat confusing.
Sure. So the cross appeal arises out of Tecton's failure to satisfy express conditions preceding. And the law on that is pretty clear. A general promise or an implied condition can be satisfied by substantial compliance, or it can be waived. An express condition preceding cannot. It must be literally performed. Here,
And there's a no waiver clause in
no waiver clause as well.
in your now. I think something you said there was very interesting, that it's pretty well settled, because I think I'm not sure how well settled it is, but even if there's not an express compliance, can they use a course of conduct to show that there may be an issue of fact on this?
Not with respect to an express condition proceeding. And if I misspoke, I apologize. It is settled. Court of Appeals case law, express condition precedent language. That language used in a contract cannot be waived and cannot be satisfied by course of conduct. Here, in order for them to maintain their delay claim, they had to provide notice within 14 days.
Don't we have cases in this department, though, that indicates that it can be changed by course of conduct?
Not an express condition precedent with a waiver, with a non-waiver provision. And there's been nothing here that's been presented that there was anything to change that.
What is the best case that you have? Is there a Court of Appeals case that
yes,
delineates that particular standard and an express condition?
Oppenheimer is the Court of Appeals case.
That's okay. I think we could probably find it.
Because the key,
Take your time.
It's Oppenheimer and Schindler.
Thank you.
I'm sure you're familiar, we have some cases that say, even where there is a no waiver clause, a sufficient enough, it's debatable what that can constitute, a sufficient enough course of conduct can overcome the no waiver clause. But you're saying that when the matter that it allegedly was waived is an express condition precedent, that doctrine doesn't apply.
That applies to general promises, a notice that says you need to provide it by certified mail and you provide it by email. That's a course of conduct, even without a waiver or saying that it's been waived, saying, hey, I have actual notice, I don't need you to send me the certified mail. That can work for a general implied condition, but not an express condition preceding like we have here.
All right, thank you.
Judges, I'd like to address 2 points. The first issue, which I wanted to get to initially, which I didn't get to, was my second argument on the issue of verification. And clearly, under the lien law, it's been the law in the state of New York since the 1800s that a person can sign upon information and belief. Mr.
Right,
Gashi,
but the deposition basically indicates that he didn't have any information because he didn't have anything that he really relied on to.
he relied upon what Mr. Mark Hyman told him. He was asked that question, we put it in our brief. He said, Mr. Hyman gave me the lien. He said he prepared it. I relied upon what he gave me, and he signed off on it. At the end of the day, he's allowed to sign off upon information and belief. And it's not like Mr. Gascione totally worked in a vacuum. He was involved in the project, and signing off upon information and belief is acceptable. In fact, in the state
But it didn't appear from his testimony that he had any real information about what was contained in the lien.
I cannot disagree with you on that.
Okay.
But that doesn't make the lien invalid. Because he didn't have the actual knowledge, he signs it on information and belief, that doesn't make it invalid.
With respect to the willful exaggeration, does your position that a triable issue of fact exists on that topic rise and fall on Mr. Hyman's affidavit?
That's correct, Your Honor. Yes.
And how do you address Justice Guzman's observation that Mr. Hyman's claim that the misstatements regarding the amount of the lien were inadvertent, were quote unquote conclusory?
Judge, I think that was a conclusion that was reached without any legitimate basis. We submitted an extensive affidavit of Mr. Hyman. We submitted 632 separate pages of backup to support our lien claim. So how she could say it was conclusory is just, I'm at a loss for it. If I may be very brief on one last point.
I'm going to allow you.
Thank you, Your Honor. I appreciate that. On the issue of delay, I'll just say this very briefly. The court specifically found, this is a direct quote, Tecton has submitted extensive proofs about delay. They had actual notice of every delay on this project. There were 39 different project documents that put them on notice of the actual delay. On April.
But I mean, these specific types of contracts in this construction field seem to be interpreted very, very narrowly. And if there are, as your friend says, an express condition precedent, is the knowledge you're claiming and everything else enough?
Yes, Your Honor. And Judge, I would respectfully submit, it would appear to me that the more modern approach, let's say, is to be more indulgent when a person has actual notice, and the courts have been, I would respectfully submit, less inclined to rigidly enforce those type of provisions.
I'll look to see if you have those cases in there, because having sat on some of those cases, I'm not sure I agree that that's what we've been doing, but I'll look at them.
I gave them to you in my brief.
Okay, I will look at them again.
Judge, the last thing I would like to say is, it's really, just from a practical level, unfair. When a contractor as delayed as they were here, and he puts a request in for an extension of time, and they refuse to sign it, and then they tell them, no, we'll deal with that later, and this is all part of the record. And then when they acknowledge, at least on the front end of the job, 69 days of delay at the very outset on supportive excavation, and then when they put their insurance carrier on notice of their design professional's defects, which delayed the project by hundreds of days, and they can stand up here and submit to this court that that the contract doesn't allow us for a delay is wholly improper.
Thank you.
I appreciate it.
Sure. Matter of Emily D.
Okay.
Oh, I forgot. Forgive me, please. Thank you.
I'll be brief, Your Honor. Just addressing the inadvertent response. We've cited case law, LMF, RS, Contracting, Inc. That's not good enough. You need to raise a good faith dispute as to why those claims, like that $1 million, was included. Just saying it was inadvertent is not enough. Judge Guzman got that right. With respect to information and belief, counsel says that a lien can be verified upon information and belief. That is not accurate. Any document, whether it be a complaint, a petition, or a lien that is required to be verified upon information and belief cannot be wholly verified upon information and belief. There can be certain allegations, but if the entire basis for the pleading or the lien is upon information and belief, it is not verified, and we cite cases to that effect as well. And finally, with respect to the express conditions precedent, I think this is an important point. It is not just notice. And look, I can go back and counter all the things counsel said about the delays and the facts. It's irrelevant. It's what's in the contract, and it's an express condition precedent, and it's not just notice. They were required to provide a mitigation plan. Explain to me how you're going to limit this delay, when it started, how many days, a critical path analysis with showing other concurrent delays and how this actually impacts the project. This was not a boilerplate provision. This was a negotiated provision that we negotiated for and specifically added that it was an express condition precedent because these are important pieces of information to any sort of delay claim. And if we don't get it, this is what happens. At the end, we get a lien that's grossly exaggerated. They throw everything in there and nothing can be confirmed by the owner. There's no further questions.
Thank you both.
Thank you.
Thank you.
Thank you, Your Honor.
Matter of Emily D.
Good afternoon. May it please the court, Bruce Young on behalf of the appellant, Emily D. It's been a long day. There's still more people behind me, and I don't have anybody to argue against, but I do want to just raise a point or two that I think will give clarity that I hope doesn't get lost in the record. The reason we're here is because the family court referee, in his oral-only decision on the family offense Article 10 petition, said, I don't see really proved by competent evidence that the father said he would use his weapon, his gun, to shoot the appellant and the children's stepfather. Says it wasn't really proven. So there's the issue of competence, and it's a joint proceeding of an Article 6 and an Article 8. One, the Article 8 case law, and it has more rigorous competence of its evidence. What I think gets overlooked is, and the children went to see their father for the first time in Texas. They're there for a week. He admits that he's drinking half of the time to the point of drunkenness. He admits that he's waving.
Well, counsel, is this in relation to your argument relating to the menacing count and the elements of menacing?
Exactly right, yeah.
Right, and so what course of conduct or repeatedly committed acts over a period of time were established?
Well, the fear was established from a pattern of behavior of his. There's a court record of many, many proceedings between the two of them. Her reasonably objective fear over the course of conduct that they had over a period of time, I think, was established. There was fear. I don't know that that was the issue that he had here. He said, what were you afraid of? He asked her, but I think he overlooked that there was a long record of that behavior.
You know, if I may,
Sure.
We're talking about, you know, the dismissal of the family offense petition, right? But that was an unsigned transcript, and there's no appeal from an unsigned transcript.
Here was our problem. During the course that I was preparing the appeal, I made a motion to expand the record because I'm not sure it's there was an unsigned transcript and not a. You mean it from the judge's decision? Or?
Yes.
That's all, yeah, that's all we have here. So there's an element, there's a procedural.
There's a
glitch.
problem there.
Right. The problem is that this is a referee. And a referee has to have consent by the parties. There is absolutely no evidence of it in the record. So my adversaries who aren't here would say, they waived it, she
But you didn't challenge the, you didn't challenge the referee's authority, and there's case law here that says, you know, that there's implicit consent when you actively participate without challenging the jurisdiction. That's what we have here.
That would be one potential remedy. The other would be for the court to remand it to a family court judge to either hear and determine, because it wasn't determined on the consent of the parties.
Let me ask you this, because the mother withdrew the order of protection for the children. What more safeguards are needed in addition to requiring the father to store the firearm in a storage facility? We know this is in Texas. Things are a little different in Texas.
Right.
Okay, right? And to abstain from alcohol during visitation. What else would be needed? What other safeguards?
Which gun would be my first question, because one gun only was identified that was waved in front of the children saying, I'm going to kill your mother and your stepfather if anybody hurts you. So that's, it doesn't, there's not an remedy to say that that protection regarding any or all guns, which are pretty, I'm assuming pretty readily able to get in Texas. The other thing is, there's no order of protection connected to it. So where there's full faith and credit under federal jurisdictional statutes for orders of protection, that's not a family court referee that says, don't drink and put your gun in a secure location someplace else and send it to the mother before you go for and she'll schedule the visit. It also puts the burden on the mother that whether he's complied or not, there should be some greater mechanism for compliance that addresses the visitation issue.
All right.
On the order of protection part, though, there's something that's lurking in the record. The kid said something. It's hearsay, except it may be admissible hearsay under the Article 6 because it involves something that could be neglectful, like in Article 10. In Article 8, you can't do that, except remember this. After he said it to the kids, she got on the phone with him, said, did you say you threatened to kill me and my husband after waving a gun in front of them? He didn't deny it. He didn't deny it on the phone call. He didn't deny it when she got on the witness stand and testified to it, which is competent evidence. And his non-denial and just saying, I'd do anything to protect my kids is not an adequate denial. So it's a competent evidence of an admission against interest for the purposes of establishing competent evidence for why there should have been an order of protection.
All right, thank you so much. Thank you.
Thank you.
Air Products and Chemicals, Inc. v. World Energy, LLC.
Good afternoon, Your Honors.
Good afternoon.
Matthew Merconic on behalf of Defendant Appellant World Energy, LLC. Here, the trial court granted Plaintiff Air Products motion for summary judgment in lieu of complaint under CPLR 3213 and entered judgment in the amount of $343 million. The trial court did so without a hearing, before any discovery, and at a point.
How did the trial court determine damages here, determine how much was owed?
Thank you, Your Honor. So what the trial court did is the trial court essentially accepted, in terms of the initial amount of damages, accepted the amount that Air Products submitted in the declaration in support of its original motion. And then there was a subsequent set of briefing on the amount of sort of additional interest and whether or not there was an offset based on an offset right that Air Products had expressly invoked under the credit agreement, given lease payments that it owed to World Energy.
So the determination, was it readily ascertainable from the guarantee itself, or were other extrinsic documents necessary to make that determination?
That's a great question, Your Honor, and I think it goes to the heart of all the different independent grounds for error that we raise in the case, which is this case did not meet the threshold requirements for CPLR 3213, even to determine whether or not any interest payments or principal payments were owed. The court had to make interpretations of other documents, including the master project agreement, which I'll refer to as the MPA, and make factual determinations under that agreement as to the status of the refinery plant expansion and optimization work that Air Products had been contracted to perform, and what the operation status of that refinery was.
You said that was really just to determine the amount of the interest, but what about to get the $343 million basic number? Was reference to other documents other than the guarantee necessary?
Yes, Your Honor. And the reason for that is that there are, in order to determine what interest rate applies under the credit agreement, and in order to determine whether or not the parties' relationship is even at the stage where any interest payments or principal payments are due, the court necessarily has to make determinations about the status of the project and the status of production at the Paramount Refinery facility. In addition, there are terms in the credit agreement and the MPA that provide that in the event of what's called an MFF deferral event, that all payment obligations, including obligations to pay interest and principal under both the credit agreement and the MPA, and again, what Air Products is suing under is a guarantee to enforce the obligations under the credit agreement.
With respect to the credit agreement, I think 3.6 of the credit agreement indicates that the parties recognize that resort to 3213 may be had. Did your client consent to or chart a 3213 course by virtue of 3.6 of the credit agreement?
I appreciate the question, Your Honor. What's important to note is that that provision is contained in the credit agreement, which is not the instrument on which Air Products sought summary judgment below. They sued under the guarantee, which includes no such provision. I would also submit, Your Honor, that even if that provision had been in the guarantee, which is the instrument they sued under, and it wasn't, that would not be sufficient to bring that instrument under the procedure of 3213 if, in fact, that agreement doesn't meet the substantive requirements set forth in the statute for summary judgment under 3213.
This MFF deferral event, now, did that take place prior to the acceleration of the default? Because I know that, the acceleration took place March 31st, 2015. Now, was there a declaration of an MFF deferral event to, suspend the payments?
So the acceleration took place, I believe, March 2025. Under the MPA and the credit agreement, there's no obligation for World Energy to, quote unquote, declare an MFF event. That's the argument that Air Products makes in the case. What the contract says is that what World Energy does is it suspends payment. That's the action that it takes. And in fact, the only reporting obligations or noticed obligations related to an MFF deferral event go to Air Products. They are all Air Products obligations.
Were the calculations that were done here made based on readily available information?
In terms of the calculations to determine the interest and principal?
Yes.
We would submit no, Your Honor. And in fact, our argument is that because of both the MFF deferral event and the existence of a dispute which predated the litigation, it was sent in April of 2025, the dispute notice that World Energy sent, both of those things independently suspend all payment obligations under both the credit agreement and the MPA. And so given that, there was no present payment obligation by the primary obliger, Altair, that could give rise to a claim under the guarantee against World Energy. And that's not in dispute by either party, and controlling New York law requires that.
Now, besides payment, what other additional performance was required? Besides payment, what other additional performance was required?
Thank you, Your Honor. So this is one of the two reasons why the guarantee does not meet the prerequisites for CPLR 3213. And that's because Section 1 of the guarantee says, the guarantor hereby and unconditionally guarantees the due and punctual payment in full when due and performance of all the borrowers, the guarantors, and any other obligers' indebtedness, financial liabilities, and obligations of whatsoever nature and however evidenced owing to the secured parties under the credit agreement or any other agreement contemplated by the credit agreement. The credit agreement expressly references and contemplates numerous other agreements, including the MPA or Master Project Agreement.
So these could cover requirements other than just the payment of money only?
That's exactly right, Your Honor. Essentially, what the guarantee does is it guarantees all payment obligations and all other contractual obligations, not just under the credit agreement, but under any agreement contemplated by the credit agreement.
All right, thank you.
Thank you very much.
Good afternoon. May it please the court. Scott Musoff from Skadden Arps for Plaintiff Respondent Air Products. I'll begin with the last question, Justice Kennedy, about the term performance. The cases are legion in the First Department, including 27 West 72nd Street, 194 AD 3rd, that the addition of the words "and performance" does not necessarily remove the guarantee from the category of instruments. And in fact, Your Honor, Justice Kennedy, in AB Commercial Real Estate, specifically distinguished the main authority in which my colleague cites, PDL Biopharma, precisely for that reason, that the guarantee aligns squarely with the statutory requirements of 3213 when it uses terms such as irrevocably and unconditionally guarantees the due and punctual payment in full. It's an absolute present and continuing guarantee of payment and not collectability, and is no way conditional or contingent upon any attempt to collect from the borrower.
Well,
Obligations are primary and absolute.
So I'm sorry to interrupt you. So when I asked your colleague over here, well, I know the law says that, but it adds on performance of things other than just the payment of money and makes reference to several other agreements. I mean, does that distinguish this from other cases where we might be granting 3213? I mean, it seems like it's hard to figure out what's going on here just by reference to the guarantee in this case.
Justice Kapnick, absolutely not, because the term obligations in the our guarantee, unlike that in PDL Biopharma, wasn't the defined term obligations in the credit agreement. And it's modified by the word financial. It's talking about financial obligations. It has a parenthetical about principal, interest. And it's exactly the same type of guarantee and language that this court upheld summary judgment under 3213 in BBM3 LLC versus Fasadas, in which Justice Kennedy and Justice Higgett were on the panel, 216 AD 3D.
But counsel, in order to get at what the damages were, how much was owed here, did the court not have to look at information outside of the guarantee to make that determination?
Justice Michael, in virtually every 3213, you have to look at the underlying note to determine the amount. Here, there is no dispute. I think my colleague is mixing a little bit of apples and oranges. The only dispute they made to damages was a $9.5 million set-off, and the guarantee explicitly waives any set-offs, which, as Justice Kapnick in the Friedco versus Capital Group case, 225 AD 3D, right on point. When the guarantee waives set-offs, you can't. So that's only less than 3% of the amount owed, 9.5. But Justice Schechter was correct in not setting that off in light of that language. And then the interest rate. The interest rate is contained in the credit agreement. It's a defined term. The applicable rate is 15%. There's no ambiguity. So by throwing up emails that suggest a lower amount is extrinsic evidence, which violates the Four Corners rule.
So the fact that after Judge Schechter said, okay, I'm granting you plaintiff summary judgment on 3213. I want some additional briefing, or I think it might have been letter briefing, that you each gave to figure out the exact amount. But it seemed that that was mostly the interest and the set-off. Does that affect this particular case at all?
No, Justice Kapnick, in fact, one of the fundamental premises of 3213, and maybe to paraphrase Justice Kennedy from the previous argument, we do things a little bit differently here in New York. It's a reason why lenders come to New York, choose New York law, make this commercial center. You could separate the damages from the fact that the amount is owed under 3213. So you could even have, if you needed, we didn't need it here, you could have a factual hearing as to the amount owed. Here, there was no dispute over the bulk of the amount. There was a dispute over some attorney's fees owed. We waived those. And the set-off was waived by the text of the agreement, the guarantee itself. And the interest rate was unambiguously provided for in the credit agreement.
Principal amount calculated?
It was the amount owed up to that. It was the full amount owed. In fact, there was a forbearance agreement that contained the amount that we were entitled to collect because it's an acceleration. So the entire principal just gets accelerated. And that was accelerated, to Justice Kennedy, one of your questions, well before they concocted the MFF disputes, even if those were allowed to be considered, which they can't because of the waiver of all defenses, set-offs, counterclaims. That's put in there to protect the lender. Even if it could, you can't come back after defaults and after acceleration and then say, well, now I'm going to dispute it, and then not expect to be collected on the guarantee. The guarantee is a separate, independent right
So
for Air
the
Products to collect.
Counsel, the principal amount, same question I asked your adversary, was determined by readily ascertainable information?
Readily ascertainable. It was the acceleration amount.
Okay.
And and there's no dispute over that amount.
We seem to have come a long way from the Weissman in the Court of Appeals. Simple proof of a default, no extrinsic evidence save for a de minimis departure.
You know, yes, but...
And I think you're right, though, counsel, that perhaps we've recognized the need to sort of accommodate the special inventory we see in this department.
Justice Higgett, that's exactly what I was going to say. We've moved from commercial paper type disputes, but the cases that we cite, including several by members of this panel, all involve the same thing. In fact, the Valero case that we cite talks about complex underlying agreements. And we recognize in this world we live in, the commercial agreements underlying a debt can be very complex. But what's not complex is the Section 1 of the guarantee, which in plain English talks about it's an absolute right to collect. And in fact, the preamble says, we're only doing this because you're giving us this guarantee. That's what gets people to lend money under New York law.
Thank you.
Thank you.
Sir, so how, in your view, how was the principal calculated?
So the calculation of the principal, assuming that it's owed, we can determine what that amount is. But the trigger for the obligation to repay the principal under the credit agreement is only triggered by certain things that require a factual finding as to the status of the project and the parties' relationship. And I think one thing...
I'm sorry to cut you off, but do those in any way relate to any defenses that you may have waived by virtue of this broad, unconditional guarantee?
No, Your Honor. New York law and Air Products both recognize that in order for there to be an action under the guarantee, there has to be an underlying default by the primary obliger. That's not a separate counterclaim. That's not a defense. That's part of the prima facie case. And so if there's not an underlying default, there cannot be any action under the guarantee. And if there's a disputed issue of fact as to whether or not there's an underlying default, there likewise cannot be summary judgment under 3213. That's the case here for a whole host of reasons, including the fact that there's a disputed factual issue over the existence of an MFF deferral event, which would have excused any present payment obligation by the primary obliger and thus prevented any sort of action under the guarantee. Even the trial court recognized that there was a factual dispute over the MFF deferral event issue, but she nonetheless granted summary judgment, saying that that was sort of irrelevant to her analysis. It's not irrelevant because if there is no present payment obligation, there can't be then any trigger for that prima facie case to bring an action under the guarantee. Likewise, and I just want to say too, this idea that there's a waiver, both the credit agreement and the MPA both explicitly say that any dispute related to payment can be raised within a year of the underlying invoice being served. That was the case here. There was undisputedly a dispute notice as least as early as April 7th. And so there's no waiver here.
He's going to ask the last question.
Thank you, Your
Your
Honor.
friend made an argument, so this morning when I was going through some of the case law, I was surprised there wasn't a little more authority on this. Is your friend correct that it's enough on 3213 that liability can be demonstrated as a matter of law? And then if there have to be some ancillary proceedings relevant to the amount owed, that's acceptable under 3213?
There is certainly some case law that supports that. That's certainly not what the trial court did here. And the trial court, in granting the amount of damages at the end, sort of explicitly permitted Air Products to have a double recovery of amounts that they had already expressly collected through this offset procedure under the credit agreement, and then also, recover the entire amount that they were seeking in the case. But I think all of these factual issues go to their entitlement to all of the amounts that they're seeking as damages, and that's really the core problem here.
All right.
Thank you, Your Honors.
Thank you.
You're welcome. Veloso v. City of New York.
Good afternoon, Your Honors. May it please the court, John Shaw for plaintiff appellant. Respectfully, the lower court erred when it dismissed plaintiff's labor law section 240 sub 1 claims and 241 sub 6 claims. And I will also submit to the court that clearly this is another type of falling object case where the object was not secured. Before I address that, I just want to briefly touch on the exhibits. As I said in my brief, certainly Mr. Zemek's affidavit was considered and the motion was ruled on the merits. Not only that, Mr. Zemek relied on all of these exhibits when he rendered his opinion. Moreover, all of the exhibits were annexed by defendant in his motion, the deposition testimony, etc. Moreover, Mr. Tracy, their expert in rendering his opinion, relied on all these exhibits, including the accident report by the employer, which was the only exhibit not annexed by defendant.
Can I ask you a question
Sure.
about this? So your plaintiff is down working below the ground at
Yes.
3 o'clock in the morning. And in this particular case, as opposed to the case Rivas, which Judge Higgett wrote, there was shoring on the sides. And I saw pictures of that sheeting, shoring, whatever. But he's using a tool, a chip, to chip away
Yes.
at the dirt. And from somewhere, a rock falls out and breaks his ankle. And the thing is, the whole point of what they're doing is to chip away, to move ahead, to chip away and get rid of the dirt. And there's some machine that's taking away the dirt. But they have to keep shoring it up as they move along. But they can't shore up in front of them because they got to chip away at it. It seems that the only testimony I could find, you'll correct me if I'm wrong, was that the rock came from there. So how could they have shored that up to protect that if that's what they were working at? And if that's what I don't understand, if I got it right. And I try to look at the pictures, read the expert and see if I could figure it out.
Sure, Justice Kapnick. This was a case like any of these cases where they're doing work, where they're trying, where you're removing ducts, where you're removing pipes. The goal was to remove it, but you still, in this department, has held that you need proper
Protection.
securing of the object. Here, in fact, my expert averred, he, many years of experience, he averred that through the pictures that were identified through Mr. Grappler in his incident report, which was authenticated and relied upon their own expert, he averred in his affidavit that not only were the front part of this trench not shored, but the sides even were not properly shored. And under
Was there any, was there any testimony from anybody as to where this rock came from? Whether it came from the front, from the...
my client assumed, because he was, bending at the time, that he assumed it came from the front part of the trench. It was not definitive, but whether or not it came from the side or the front, under the labor law and even under OSHA, which the expert cites too, this is something that's supposed to be properly secured. The lower court clearly erred on 240 when it cited to cases that are either were in the second department or clearly inapplicable, like Narducci and Zidius. Narducci, which they relied upon, was a case where, as this court knows, you had a window that had nothing to do with the construction. It clearly didn't.
Just very briefly, because,
Sure.
Your expert averred, all sides should have the shoring. But did he ever explain how the excavation could be done by shoring all the sides? Because, I didn't see that, right? Allegedly, I guess the rock fell from where the plaintiff was doing the excavation. So did your expert explain how that could be done if all of the areas were shored up?
They could have worked around the area when there was that obstruction, that which was noted in his diagram. They did not have to work in that particular area where my client was directed to work in. And again, Your Honor, there is nothing conclusive saying it had to only be shored on the sides, because clearly this object, which was a very large rock that broke my client's leg, caused significant damage. And what is inconvenient in the Zimmer case, where it is considered, even if it's the custom which my expert disputes about leading edge, that is not a defense to Labor Law Section 240(1). Even if it's the customary practice to do something, and let's assume there wasn't even an expert, Mr. Zemek, to controvert their expert. Under the Zimmer case and many other cases, just because it may be inconvenient or not the customary practice, the owner has the absolute liability to provide proper protection when a worker who is directed by his foreman or someone else to do work. Clearly, and even in their accident report, they acknowledged this large rock was dislodged. It was clearly not properly secured, and it's clearly, whether it's in a trench, which the lower court clearly misstated the law under Rivas and many other cases, it's not an ordinary practice of construction. This big rock fell because there was no proper bracing under the statute.
Just to be clear before we
Absolutely,
the
Justice
respondent,
Kennedy.
counsel, but the shoring did not collapse, right? It didn't collapse or fall, right? Because in my
It
understanding.
didn't collapse. It wasn't a cave-in, so to speak, but that does not matter. The purpose of the shoring and the bracing, as per my expert, is to properly secure the dirt here. And that's what, while the work was being done, this rock, which was part of the dirt and was supposed to be braced, according to my expert, it fell, and it fell a significant degree of elevation, even though that's not required. And that caused the accident. There's nothing unique about these set of facts other than it's a trench. If you put it in the context of any of the cases, whether even in the Linares case, where they were removing a scaffold at the time, and the purpose was to disassemble the scaffold, and a component fell, even though the point was to disassemble it, if it's not given proper securing, as in this case, there's a violation of the labor law.
All right, thank you.
Okay, thank you, Your Honor.
May it please the court, Brendan Fitzpatrick, counsel for the respondents. Your Honors, if I could just work backwards from Justice Kennedy, your comment. Mr. Zemek never actually said how the work could be done if it was shored on all sides, which is what they maintain, what plaintiff maintains, page 4 of his brief. He said it should have been shored on all 4 sides. According to the Court of Appeals in Salazar against Novalex, it would be illogical to shore the narrow front edge where they were actually excavating. And as they were doing this work, they had a vacuum truck. So it wasn't like Revis where they had the fill from where they were excavating posted on the side, and just placed on the side, and that eventually collapsed. This was all removed. Everything was removed as it was excavated.
I appreciate you distinguishing Revis and not saying that it was wrongly decided.
Your Honor,
That would be a bad idea.
at some point in time, I actually do understand my audience. My kids will not tell me that, but hopefully today I did. So it is actually, according to the Court of Appeals in Salazar, it would be illogical and against common sense to shore the front edge, leading edge, wherever they were excavating, whatever
I think your friend suggested, if I remember his argument, at least at what aspect of it, the work could have been modified to sort of work around the obstruction. If it couldn't be proper, at that moment, at that time, couldn't be properly secured.
Yes.
To work around the obstruction.
I think it's page 35, 36 of his brief. Again, I don't know what obstruction they're looking for. This was completely unforeseeable. Plaintiff testified he had no idea that this was going to occur, and he wasn't equivocal. He didn't guess that it came from in front of him. He was actually testified twice, page 1470 to 1472. It came from the front. He had to excavate forward, and in pages 1341, 42, it came from the front of where he was digging. So again, I don't know how Mr. Zemek or plaintiff's counsel would have preferred this narrow portion of the excavation to have been shored, to go around it. Again, they never explain how the work could have been done if they shored just where? To the left, to the right, above, below? Again, it forces everyone to guess, and part of the reason is because they never put these arguments in the Supreme Court.
What about any portions of the 241-6? There were several different sections of the industrial code that plaintiff asserted, and they all got knocked out.
Yes.
I know some might have been somewhat general. Let's not talk about them. But some of the other sections, they couldn't apply under the facts of this case?
I don't believe so. Your Honor, I will get to everything, but a 4.2K, which this court has found to be general on numerous occasions, that issue is being taken up on the Court of Appeals. It's being argued on April 12th, or April 14th. I just wanted to let the court know about that. 4.1B, this court hasn't ruled that it's too general, but the second and third and the Supreme Court in the WODS case, WODZ, They have found that it's too general. This court just hasn't reached that issue yet.
Which section was that?
That is 4.1B. Again, that was
Thank you.
one that Mr. Zemek identified for the first time ever in ops. The plaintiffs had 4 BPs, never cited to it. So I think on that ground alone, it should be dismissed. Also, that deals with no person shall be permitted to enter a trench or an excavation if exposed to bank failure or cave-in. There's no cave-in here, and the bank is identified as we defined in our papers, 29 CFR 1926.653 subsection C. It defines a bank as a mass of soil rising above a digging level. There was no mass of soil placed above the digging level. This was essentially the leading front edge of where he was digging. So therefore, that is inapplicable. Next, 23-4.2A, trenches must be appropriately assured and inspected by a designated person. Mr. Tracy testified there was shoring on all 3 sides. Again, as the court ruled on pages 14 and 15, Mr. Zemek, neither plaintiff, identify how it could have been, the front edge could have been shored. With respect to, if they were still excavating, with respect to inspection by the designated party, Mr. Grabler testified without debate that he inspected it, as well as DNS's timberman. They inspected it at either 10:30 or 11 the night or the morning, the evening right before the accident. And there was no issues. Even after the incident, they inspected it again. Nothing had to be done to any of the shoring or sheeting. Your Honor, if I could just go through the last 2, I believe, I will be very brief. I just wanted to answer.
I'm going to allow it.
Okay.
Go ahead.
Section 23-4.2B, sloping sides for trenches. This was a vertical trench. Mr. Grabler, Mr. Buddha testified without debate that it wasn't sloped. So again, the vertical, that takes that out. Lastly, 23-4.4A, the sheeting or shoring has to be in compliance with the prescribed table. Again, Mr. Tracy testified that these were all in compliance. This was a vertical. There was no debate with respect to the sheeting with clean wood, with cross bracing on it. You've seen the pictures. There's nothing wrong with the trench or the excavation in this case. And if there are no further questions, I would ask the court to affirm. Thank you, Your Honor.
Thank you.
Salazar is a completely different set of facts here. Salazar, they were installing concrete in the basement, and in order to do that, it had to be leveled off. It was impossible for them to put some kind of protection. That's a different set of facts than what's going on in this case.
But how, I still don't understand how they could have put a protection if they were pushing for it. I mean, how could they do that? That's what.
The point is, Your Honor, is that the whole area was unstable that caused this rock to dislodge. That is Mr. Tracy's self-serving analysis, and Mr. Grappler, who was submitted an affidavit which doesn't state any of that in his very voluminous accident report, where he said the rock was dislodged, but then they asked him to do an affidavit to say everything was fine. First of all, there was no checkoff or certification, which was required under a 4.2A. But with respect to Labor Law Section 240, this was clearly an object that was supposed to be secured, and it doesn't matter what's inconvenient. It doesn't matter what, part of it, it was impossible to have been shored for them to do the work. That is their again, conclusion. And again, that runs afoul of Zimmer. And in fact, they're talking about Mr. Tracy. Mr. Zemek even said that it was supposed to be, not only supposed to be shored on all sides, but he also, in paragraph 16 of his affidavit, even averred that had the crew been directed to excavate from a different direction and from the top down, the hard and compacted soil could have been safely excavated without having workers exposed to the dangers of falling from the above hazard and an unshored, unsheeted, and unbraced trench wall as they were. The whole decision of the lower court on 240 was based on its erroneous reading of the labor law, where it just said it was the ordinary perils of a construction site, and it cited the cases that were Fourth Department, Third Department, Second Department, Zidius, which a Second Department case which involved a window that had nothing to do with the construction, that didn't even hit the ladder, it hit the worker. There was nothing wrong with the ladder that caused the worker to fall, the window, and it clearly was not a 240. All of those cases are clearly inapplicable. Revis is one of many cases that shows that this is an object that clearly should have been secured. It was improperly shored. And in Revis, they did shore two sides. Here, they shored the sides, but again, my expert said through the photographs that were exchanged and authenticated that these sides were not properly shored. There was no shoring, which disputes what they said, and the object failed. Last thing I'll quickly say is...
That was the last thing. Thank you.
Thank you, Your Honors.
State of New York, Phone Administrative Services, Inc., v. Verizon, New York, Inc.
Thank you, Your Honor. May it please the court. This case is about whether a reasonable jury could find that the New York False Claims Act applies to telecommunications carriers that systematically shorted the enhanced 911 system and filed false reports to conceal that. I'd like to focus on two main points. The first is the party's primary dispute, which is about the meaning of the phrase access line. For reasons I'll explain, the way to count access lines is by counting telephone numbers. But second, and I want to make sure I get this out, even if the court disagrees with me about the meaning of access lines, there are important claims in this case that nevertheless should have survived and gone on to trial. First, Verizon did two separate things that were wrong. They treated entire counties as a single location for purpose of capping surcharges when they should have been capping it to like a single office. They also claimed that they wanted to use concurrent call capacity and so count 23 access lines per PRI, but one of their divisions only capped it at 5, therefore violating their own standard. The defendant, WiMAX, didn't collect surcharges at all from 80% of its customers. We talked about this in our opening brief. The defendant's brief said literally nothing about it.
Well, let's get right to the chase, because the statute talks about access line.
Your Honor.
Doesn't talk about telephone number. So how do we get there?
Yes,
How
Your
do we
Honor.
get from access line to telephone number? Because it doesn't say it.
Yes, Your Honor. The only definition of an access line in New York law does in fact reference telephone numbers. It's the regulation by the Public Safety Commission, which itself administers the E911 statute. That regulation says that an access line is a telecommunications channel with an associated telephone number. We argue that that one-to-one correspondence, a telecommunications channel with an associated telephone number, tells you how to count access lines. Now, the defendants criticize this definition. They say it's not specific to the E911 law, and that's true. But it is the only definition in New York state law. It is also entirely consistent with how New York City, which is the largest relevant jurisdiction in this case, interprets their E911 statute. For example, we cite, and this is on pages 13 to 14 of our opening brief, an audit of Verizon by the New York City Department of Finance, where they said, you are required to impose a surcharge on each telephone line, landline and VoIP. So what we say is that access line really just means a telephone line, as you would normally think about it.
But if there's an ambiguity in the underlying statute, should that ambiguity, should that inure to your friend's benefits, since here we're talking about false claims?
It certainly could, Your Honor, but we think this ultimately becomes a factual question. The case that addresses this on point is a U.S. Supreme Court case that we talked about in our brief. This is U.S. ex rel Schutte versus SuperValue. And the holding of that case, in the case, the lower court held that when a law was ambiguous and the defendant's conduct fell within a reasonable interpretation of the law, it was not possible as a matter of law to find that the defendant acted with scienter. The U.S. Supreme Court unanimously reversed. And what it explained, and this is under the Federal False Claims Act, but the scienter standard is identical under the New York statute. It said, what really matters is what the defendant subjectively believed, not what some reasonable person could have believed. And so it would still be a factual question as to whether there is scienter. And it's seldom granted on, summary judgment is seldom granted on scienter for that reason. There's also additional quite probative evidence of the defendant's understanding that I think is helpful here. So for example, there's a document, you'll find this in our appendix at page 1007, where Verizon is charging others for maintaining its E911 database. They say, for each telephone number entered into the 911/E91 database, a per access line charge applies. This is Verizon's own understanding of what a per access line charge refers to, each telephone number. Similarly, the defendant bandwidth did count access lines by telephone numbers, and they still do. We didn't sue them on that basis. AT&T counted access lines by telephone numbers until 2010, at which point, for competitive reasons, they shifted. They said, oh, we're taxing our customers more than our competitors. Let's drop this.
I want to go back for a second, because I know you're relying on the Public Service Commission, right?
Yes, Your Honor.
And you're focusing on what, rule or regulation 602, something like that?
That's correct, Your Honor.
Okay. So now, but that's part of the rules setting service quality standards for local telephone companies, right?
That's correct, Your Honor. It defines the reporting requirements.
All right,
Yes.
but I'm going somewhere. Okay, so what authority does, and I'm just going to save my breath, PSC have to even regulate how local governments in New York impose taxes, including the 911 charge? I mean, they just regulate the rates, right?
So, Your Honor, first, we dispute that this is a tax, but putting that aside for a moment, it's not a question of what authority they have to regulate this. The point is there is one definition and only one definition in New York state law. And we believe it is the correct definition. I also just want to say, even if you don't look at the PSC definition, there are a lot of contextual cues that would tell you that we are right about what an access line means and the defendants are wrong. So the defendants are saying it's concurrent call capacity. That's what you measure. Find that in the E911 statute. You cannot. Find it anywhere in New York state law. You cannot. The county law, which created the E911, the enhanced surcharge, actually really supports this quite strongly. I see my time is up, but if—
I'll let you finish that sentence, though.
Okay. If you look at multiple sections of the county law, Your Honor, Section 300 points to the need to fund things like automatic location identification and automatic number identification. Those are phone number-based cues that differentiate E911 from regular 911. That's what this surcharge is all about, and that's why it makes sense to look to telephone numbers. If you look to County Law 305 sub 4, it talks about, 304 sub 2, it talks about how the surcharge should be imposed, have a uniform application and be imposed throughout the entire municipality to the greatest extent possible. There is no dispute that what their interpretation does, Your Honor, is simply give a windfall to big businesses. They are the ones who use the types of circuits the defendants are talking about that allow them to rely on concurrent call capacity to pay less. Residents, small businesses, all are affected worse under their interpretation, defeating the uniformity objective.
Thank you.
Thank you.
All right.
Thank you, Your Honors. Greg Skidmore on behalf of the defendants' respondents. There are multiple independent grounds for each of the trial court's holdings that support affirmance here. And PAS is doing its best to muddy the waters to try to avoid the clear law and the undisputed factual record. But it can't do that. Your Honor is exactly right. The statute says access line. It does not say telephone number. And Your Honor, you're also correct. Any ambiguity here inures to our benefit. This is a False Claims Act case. It is not a regulatory violation case. So PAS has to be right that access line means telephone number, but that is not sufficient. They also have to show scienter, which is that any defendant believed that it was supposed to assess on the basis of telephone number, and it did not. And they cannot show either. There's also a third independent basis for holding. Under Section 189(4)A, because the 911 charge is a tax under this court's decision in Kessler, the False Claims Act imposes additional requirements on the claim. It can only be brought against the payer of the tax, the person who owes the tax. That is not the defendants. The defendants do not owe this tax. It is the telephone customers that owe the tax. So that's three separate independent bases for affirmance.
We go back to scienter.
Absolutely.
So as the movement for summary judgment, you would have to make a prima facie showing, right? And you'd have to make an affirmative showing, not enough to point to putative gaps in the plaintiff's proof. How did you discharge your prima facie burden on the issue of scienter?
Your Honor, the undisputed factual record is that the defendants believed that they were interpreting the 911 law correctly, and they believed they were assessing the 911 charge correctly. We cite this throughout our brief, and it's every defendant who was deposed said the same thing. They believed it. And that makes sense because the defendants are just a pass-through here. They collect the money from their customers, they remit it to the government. They don't make any money on this. And this is unlike any other False Claims Act in the entire United States of which I am aware, because PAS does not allege that we stole money from the government. They don't allege that we kept money for ourselves that was supposed to go to the government. And that's different from every other False Claims Act case. And counsel also referenced the super value case. This case is very different from the super value case. In super value, there was evidence that the defendant believed it was doing it wrong and nonetheless persisted to go with. And so counsel is right that if there is subjective evidence that the defendant knew it was doing it wrong, that can't be overcome with an objectively reasonable interpretation. But there is no such evidence in this case, and that's how we satisfied our burden. And counsel also referenced New York City. So the PSC, let me just start with the PSC definition. First of all, it is correct. It does not regulate 911 charges. But PAS also misreads the PSC definition. It defines an access line as a telecommunications channel. That's how it defines it. So to count access lines, under that definition, you count channels. Well, which channels do you count? You count a channel that has an associated telephone number. So a voice line that has an associated telephone number is counted as an access line. A data-only channel, which does not have an associated telephone number, is not counted. So they're wrong on multiple scores on the PSC, which is why they try to add words in. They keep saying things like a one-to-one correspondence or a unique identifier of a channel. None of that is in the statute. None of that is in the regulation, and none of that is accurate. There are legions of businesses for which there are more telephone numbers than there are channels to the outside, which is why in so many businesses you have to dial 9 to get to an outside line. In New York City, PSC does not have the right definition. New York City, which accounts for 75% of the alleged damages in this case, has a definition of access line in its administrative code. And that definition says it's a communications circuit. It's no mention of telephone numbers. We deposed someone from New York City and said, what do we put on the form in New York City? And they said you put in access lines. No mention of telephone numbers. So they're just wrong on that. So instead, PAS is throwing a bunch of mud at the wall to see if they can get something to stick. And they talk about geocodes, and they talk about 5 versus 23, and they talk about other things like that. None of that was PAS's argument below. What PAS is saying here is that the defendants committed knowing fraud because they did not bill by telephone number. That is what they argued below. That is what their expert calculated damages on. That was their main argument. And just to be clear on these points, so on the question about the Verizon companies. So the undisputed record evidence is those companies operate independently. They have independent billing records. But it's all a red herring because PAS says they're all wrong. Every defendant is wrong because no defendant assessed on the basis of telephone numbers. And they say it was knowing fraud to not assess on the basis of telephone numbers. Also, PAS cannot establish materiality, which is a required element of the False Claims Act, on these separate theories that they're pushing now on appeal. And they can't establish materiality because they did no work below to establish what, if any, difference it would have made. Remember, Verizon remits over $20 million a year in 911 charges. And there's a materiality standard under the False Claims Act. So PAS had to put in evidence that it would make some material difference. They put in no evidence on the 5 versus 23 point. They also put in no evidence on the geocode point. And on geocodes, the undisputed record evidence is that geocodes are a common way of assessing taxes. That's undisputed in the record. There's also a federal court case, the Hamilton case, which we cite on page 51, that says it is a reasonable. So we have both a court case and we have the undisputed record evidence saying that there's no problem. And that record evidence is at Respondent's Appendix 3726 and 3547. As to the regulatory filings, so PAS's own president testified as to the regulatory filings that they, quote, have nothing to do with the 911 charge. And so PAS cannot come now and say that they do when their own president testified they have nothing to do, and that's Respondent's Appendix 2181 and 2182. And on our brief, pages 36 through 40, we go in detail about how that's an apples to oranges comparison. That database that PAS is referencing lists locations, physical locations. It is not a count of access lines. It is not a count of telephone numbers. So it's apples to oranges, and it makes no difference here to the primary arguments. Finally, Your Honor, as to WiMAX and to bandwidth, so WiMAX is unique. WiMAX determined it was not required to bill 911 based on the unique characteristics of their product. It has nothing to do with any other defendant here. And as with the claims against all the other defendants, PAS's arguments are about alleged regulatory violations, but they cannot show scienter and they cannot prove a False Claims Act violation.
Thank you.
Thank you, Your Honors.
I'd like to start, please, just on this question of scienter, and it's important to foreground what the standard for scienter is. Although the False Claims Act sounds in fraud, the statute expressly provides that it does not require proof of specific intent to defraud. Instead, scienter can be established with actual knowledge, reckless disregard, or deliberate ignorance. And we rely, I think, on reckless disregard and deliberate ignorance here for good reason. The defendants, as the Supreme Court explained in SuperValue.
How exactly are you alleging the reckless disregard?
Yes, Your Honor. So I think here's what seems clear there was a lot there, but here's what seems clear. Access lines isn't self-defining. It doesn't mean concurrent call capacity always, like they say. It can be interpreted the way we say. So let's say the term is ambiguous. Let's go ahead and spot them that. They can say, we honestly believed it meant this thing. But our point is that when you are confronted with such an ambiguity and you are a company in the defendant's position, it is your duty to make reasonable inquiries about what the law requires. Instead, here is what they did, and we cited this evidence before. They were previously doing it by telephone number. Bandwidth still does, and they only changed for business reasons, not because anyone said, hey, this is the right interpretation of the law, let's change it.
So you're saying, I mean, that constitutes reckless disregard?
When you are aware of a subjective risk that your interpretation is wrong and you adopt it anyway, if it turns out you are wrong, that is the definition of reckless disregard in this context, and the Supreme Court of the United States said so in Super.
Did they receive any notice that their interpretation was incorrect? Because in SuperValue and Snyderman, that's what happened, but did they receive any notice to say, this is incorrect?
At a minimum, Your Honor, the instructions that New York City gave for filling out its forms make this pretty clear. They say you're supposed to remit per landline device and per VoIP device, and devices are the phones that you're picking up off your desk, each one of those having its own number. There is no, so yes, we do think they had notice, but I want to be super clear about this, Your Honor, that when he says that there is undisputed record evidence that they believe they were doing the right thing, what he's referring to is simply self-serving testimony. They have introduced not one contemporaneous document from back then saying they thought they were doing the right thing at the time.
Thank you.
Gavin?